The Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Yes, thank you, Commissioner. Today I appear with Mr Freeburn. There will be three witnesses who give evidence. The Honourable Senator Marise Payne, who will commence, then Ms Colleen Taylor, an employee of the Department of Human Services at least at January 2017, who gives information about process within the department and her correspondence with the Secretary. And thirdly, Mr Anthony Barford, an employee of the Department of Social Services during the relevant period as a member of the Debt Policy Team. Do you have a copy of the exhibit list before we move to the additional appearances?
I do.
It's convenient at this stage to tender the list of exhibits commencing 2491 through to 2555, which are all the exhibits for the day.
Thank you. Those documents will be admitted as exhibits with the numbers they bear in the schedule. Ms Hogan-Doran, oh, I'm sorry. I'm just used to Ms Hogan-Doran next. You're back with us?
I am back, thank you, Commissioner. I appear this morning with Mr Glover of Council.
Yes, and... and you need your microphone on. Thank you. Yes, Senator Payne, will you take... you're calling Senator Payne, Mr Gregory? Yes.
I am, yes.
Will you take an oath or an affirmation?
An affirmation, Commissioner.
Thank you. Would you mind standing, and that will just be administered.
Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Yes, Mr Gregory.
Yes, thank you. Senator Payne, you were issued with a notice to give a statement and produce documents identified as NTG-0032, dated 18 October 2022.
Yes, Mr Gregory.
And you produced two statements in response, one dated 18 November 2022 and the second after you were provided additional documents by the Australian Government Solicitor dated 9 December 2022.
That's correct.
And in those statements, you refer to various documents, and there are others which have come to your attention in the recent days.
Yes, that's correct.
Thank you. I go back to the start. You were elected to the Senate in 1997,
Yes,
and you have remained continuously elected to the Senate since that time.
yes, I have.
In 2013, you took on the role of the Minister for Human Services.
Yes,
Specifically the 18th of September 2013,
that's correct.
and you held that position through until 21 September 2015,
Yes,
and you were then appointed as the Minister for the Defence and to other ministries subsequently.
yes,
In your capacity as Minister for Human Services, you had regular interaction with the Secretary and Senior Executive Service within that department.
yes,
And during this period of time, the Secretary was Ms Catherine Campbell.
that's right.
In December 2014, that is after you'd been in the position for a little over 12 months, Minister Morrison was appointed to the position of the Minister for the Social Services portfolio.
Yes,
And as between you and him, he being the portfolio minister was the senior minister,
that's correct.
as it's designated.
And in fact,
And that meant that you were not automatically a member of Cabinet in the position that you held,
I was not a member of Cabinet at all.
and Mr Morrison was.
That's correct.
Irrespective of whether you were, that is, despite the fact you were not a member of Cabinet, there were occasions when you attended Cabinet meetings, specifically Expenditure Review Committee meetings from time to time as required.
I think I would recall perhaps the instance that is the subject of this discussion and few others for junior ministers in portfolios to attend Cabinet or ERC. The opportunity doesn't arise that often.
And in what circumstances does it arise?
If you have specific portfolio responsibility for a measure which may be coming before the Cabinet or the Cabinet subcommittee. It relies on you being called into the room in a timely manner. I have been outside the Cabinet room, been called and entered the room and had the matter already dealt with before I entered the room, so it depends on each circumstance.
When there was an aspect of portfolio responsibility, would that concept apply to this particular measure which is addressed in your statement?
Yes.
You outline in your statement, Ms Payne, that you went on leave 24 December, that's Christmas Eve 2014, through to 9 January 2015 inclusive.
Yes.
That is Friday the 9th of January 2015. And when you returned the following week, there was the first of a series of meetings which related to what was ultimately a new policy proposal introduced in the 2014-2015 budget, which was a portfolio responsibility of yours.
That is, Mr Gregory, to the best of my recollection, aided by access to my calendar and some notes, a number of meetings at the commencement of the new year, which included consideration of this issue, but also many other matters.
And to get to the point, your recollection of your involvement in this particular proposal is limited largely to the content of the documents that you've been able to review at the time.
Given the effluxion of time, which is almost 8 years, that is correct, yes.
Before you went on leave, you signed a letter to Mr Morrison which really introduced him to the portfolio and offered that your secretary, that is Ms Campbell, would meet him during the break or at a time convenient to him.
That's correct, yes.
If I could have Exhibit 2497 produced, CTH.3732.0001.008. This is the letter. Ms Payne, this is one of the documents that you've had the opportunity to view in your preparation.
Yes, that's correct.
Yes. The overview of the department is set out over the various pages, and in the fourth substantive paragraph on that page you identified the arrangement that was proposed between Ms Campbell and Mr Morrison to brief him on key priorities and challenges for the department.
Yes.
And if we could go to the second page, please, ending 0009. And the priorities for 2015, including the first substantive paragraph after subparagraph A, could be called out.
Yes, I can see the paragraph.
You can see the paragraph, yes. What is identified there is that the department had a number of measures which it was due to implement to commence on 1 January 2015.
From the previous budget, that's
From the previous budget, that's right. But there remains a number of other measures that await passage. Are you referring there to measures that await passage through the Senate?
through the Parliament broadly speaking. I can't specify which measures they were now, but yes, that would be the normal language that would be used.
The composition of the Senate at that time, this may be something you can recall independently, but try and be specific about it. Of the 76 Senate seats, the Coalition had 33 and the Labor Party had 25, the Greens had 10, the Palmer United Party had 1, there were 4 independents, 1 representative of the Liberal Democratic Party, 1 Family First representative and 1 senator from the Australian Motoring Enthusiast Party.
Are you sure about Palmer United, Mr Gregory? I thought there were 3. Perhaps it doesn't matter very much, but
My total comes to 76.
all right. Well,
think-
it must be right then.
I think, Commissioner, they may have left the Palmer United Party at different times.
That's true. They came and went.
That they may form, of the 4 independents, they may have originally been some additional members of the Palmer United.
I don't recall the exact timing, but it is possible, yes.
Yes, all right.
And I had forgotten about the Australian Motoring Enthusiasts.
And in terms of the numbers on the crossbench, that was a record number of 18 at that time, at least in your experience in the Senate.
I will agree with you, Mr Gregory. I don't have a precise recall of every formation of every Senate of which I've been a part.
No.
Right now here.
Of course, and I don't expect you to, but the short point is that measures awaiting passage through the Parliament generally reflected in part the difficulty faced by the
Indeed.
coalition passing legislation through the Senate.
Indeed.
If we could go down to the bottom paragraph and ask that it be pulled out, please. There was a broad statement in this paragraph, Ms Payne, that the department was working with DSS to develop new policy proposals and cost estimates for the 15-16 budget. And if I pause there was nothing unusual about that concept. There were reviews regularly undertaken in anticipation of annual budgets and mid-year economic and fiscal outlooks.
That's correct, yes.
That would fall within that category or within that description.
Yes.
In terms of the coalition position in respect of the budget, there was a general approach that sought to deliver a balanced budget over a number of years at about this time. You would agree with that?
Yes.
And one aspect of that was obviously identifying areas of savings or potential savings.
That's right.
The other, of course, is reducing expenditure in broad terms.
Yes.
When you then returned from leave, perhaps Monday the 12th of January, you soon thereafter, that is the following day, Tuesday 13 January 2015, met with the Secretary, Ms Campbell, and your Chief of Staff. You've been able to identify an entry in your diary which suggests that? Sorry, in your calendar?
Yes, we have extracted as many of those as we could for the Commission.
Thank you. And if I could go then to Exhibit 2499, this is your diary note of that meeting, Ms Payne. Thank you. And just to confirm with you, a number of matters were discussed between yourself and the Secretary that day. But if we go to the second page, the relevant passage for the purpose of this inquiry commences with the phrase Minister Morrison about 5 lines down.
Yes, I can see that.
And what you've written there, thank you, Minister Morrison dash compliance, semicolon, focus on integrity of system and integrity of outlays, semicolon, NPP, compliance now / options for future, is it?
Further.
Further. And NPP in that context refers to new policy proposal?
Yes, I
Again,
presume so, yes.
yes, all right.
And it's in the margin, whether it's a follow-up note to myself or whether it was part of the discussion, I can't now recall specifically.
In a general sense, do you recall from this meeting that Ms Campbell informed you she had met with Minister Morrison over the Christmas break and he'd asked her to prepare some proposals about the current integrity of the welfare system and what might be done in terms of the future?
I can't specifically say that I recall the meeting itself. What I
Yes.
can say from its timing in my calendar and my own notes is that that would seem to be the case. and that the Secretary would have explained to me, or detailed to me, I should say, her meeting with Minister Morrison in that discussion on the 13th of January.
Yes. What flows from this meeting is a number of briefings or draft briefings to you, which were consistent with, from your review of the documents, and I appreciate your limited recollection, but from your limited recollection and a review of the documents, the series of briefings provided to you by the Department of Human Services is consistent with your recollection that Minister Morrison asked DHS, that is through Ms Campbell, to outline the approach of DHS to protecting the integrity of the welfare system outlays and options for strengthening it.
I think that's an accurate assessment, yes.
Yes. And that appeared to be the crux of what you noted in this meeting.
In specifically in relation to the Secretary's meeting with Minister Morrison, yes.
Yes, that's right. If I could have Exhibit 2500, CTH.3784.0001.002. Ms Payne, this was the first of a series of briefings prepared by the Department of Human Services. It is signed by Ms Golightly, the Deputy Secretary, 15 January, and identified at the top as the critical date of 20 January 15. And the reason is identified as a discussion at a meeting with the Secretary and the General Manager of Business Integrity, and it seems Ms Golightly, which was anticipated for the 20th.
I believe so, yes.
Now, again, being briefed in this form was a very regular process within the department, perhaps the primary record of communication between the department and the Minister's office.
And in my experience across all departments, yes.
The introduction on the covering letter identifies the recent meeting between Ms Campbell and Minister Morrison and the request to prepare a brief on current compliance processes and options for improvement. And that was again the continuation of the context which you gleaned from the meeting a few days earlier.
Yes.
The attachment was a draft brief and proposals, which appears as Exhibit 2501, and we might turn to that, CTH.3784.0001.0004, thank you. And can I confirm what appeared from the previous document, that it was not signed by you or marked by you, and that was because it was discussed in the meeting on 20 February and returned to the department unsigned, and then further briefings were developed?
It's certainly to the extent of the material that's been made available to me, not signed by me, yes, and not marked by me.
Yes.
I can't say that that is because it was discussed at the meeting, because I don't recall whether or not this was put in front of me or whether the issues were discussed. And Mr Gregory, that is, again, an effort to recollect over 7 years a past meeting. So I can't agree that it was because of that fact, but I do know that I have clearly, on the material available to me, not signed it or annotated it in any way. And I don't specifically recall it.
No, I appreciate that. The only document which might shed some light on this is Exhibit 2517. It's not your document. CTH.3043.0069.2611. It was produced by the department, I think, and I understand that it was included in your bundle.
I saw that this morning.
Oh, this morning.
This piece this morning.
This piece this morning, yes. It's the first entry here, B15/39, current compliance processes and options. The record in the right column, and again, I understand it's not your document, simply says that Parliamentary Services advised Minister's Office, that's MO,
Yes.
it's not a direct reference to you, it's to the office, requested unsigned brief be returned as Minister Payne provided her feedback directly to the Secretary, Deputy Secretary and GM at their meeting.
I see the note, but I can't add anything further, I'm sorry.
Thank you.
Commissioner, could I just note in relation to this document which we were provided this morning that the metadata that we've been given suggests it was created in September 2020, so just after Senator Payne had left the portfolio.
Sure, I don't think it's suggested that it was contempt.
No, I didn't understand that to be the tenor of the question, but I just wanted to make that clear.
Thank you.
Senator Payne, you were able to identify from your electronic diary an entry relating to a meeting with Ms Campbell, Ms Golightly and Mr Withnell on 20 January 2015.
That's correct.
And you were able to locate notes from your diary about that meeting.
Yes.
All right. Taking those in sequence, the first is 2502 MPA.0001.00001.0086. That's the calendar entry that you were able to locate or was located for you.
Yes, that's correct.
Thank you. And the next is Exhibit 2503. MPA.0001.002.0085. Sorry, it might form part of the same exhibit. Then there's a subsequent page. Oh no, 0002.0085.
Yes, I have that.
You have that. I'll just wait for it.
Think.
I think yes. For the document manager, there is a different number to the exhibit on the screen, and the centre 4 digits end in 0002. Been given the indication it's not far away. Yes. This is the diary entry in respect of that meeting, Senator Payne.
A notebook entry, yes.
Notebook entry. Secretary, that's a reference to Ms Campbell.
That's correct.
MG, Melissa Golightly.
Yes,
And MW, Mark Withnell.
that's right.
The entry says this Data Matching Act -FR apostrophe 93. And then fraud not a strict liability offence, semicolon, Q of intent, question mark, 12 times AFP, list of 1 January changes. This is the extent, I take it, of any records you made of the meeting and what was discussed?
That is correct. We've provided all of that to the Commission.
Yes. The minute which we referred to previously B15/39 is a document you have reviewed in preparation for your statement.
Perhaps.
I'll take you back to
perhaps
it.
Since my statement.
Oh, since your statement.
May have been reviewed since my statement. It might not have been available at the time of my statement.
Yes, I understand the documents, I think, came through the Australian Government solicitor to your solicitor relatively recently.
In tranches, I would describe it as. But I have seen the document, yes. It's the one we were talking about just earlier.
It is, yes. If we could return before we do that, Data Matching Act -FR apostrophe 93, is that from 1993?
Yes, Mr Gregory, in my shorthand that is from. And I think that is a reference to the date of the Act, but actually the Act is, I now understand, a 1990 Act, so I'm not sure. Perhaps it was amended in 1993, I don't know.
It reflects at least the topic of the Data Matching Act.
Correct.
Was discussed in the meeting.
I can't say with absolute confidence because I don't recall the details of the discussion, but obviously I've made a notation, yes.
If we return then to Exhibit 2501, CTH.3784.0001.004, this is the attachment to B15/39.
Yes.
Thank you. I think that screen indicates that the previous document hadn't been uploaded yet, and so they're moving in and out of the system. The attachment to B1539 is addressed to the Minister for Social Services for Action, that is Mr Morrison.
Yes, that's correct.
And it refers in paragraph 1 to the recent meeting between Ms Campbell and Mr Morrison, where the department was asked to prepare a brief which contained the points in subparagraphs A and B. Now, in terms of your review of this document in the last few days and your review of other versions or subsequent briefings, were you able to identify that the document in some respects was rewritten from following the meeting of January 2015, but in other respects some of the core features remained the same?
If I was to consider how it progressed from this document to its next version,
Yes.
I would say that this is a lengthy document.
Yes.
That when briefing to the Cabinet Minister, it is desirable to be concise, tight, clear, whether it's coming from the department or from, in my case, via a junior minister, and that may reflect the change, at least part of the changes in terms of length of the document.
Yes.
But again, I say that for context and what my experience has been in such matters. I don't have a specific recollection in relation to the changes from this particular document to its next one, but that is context in terms of how the approach might be made.
All right. If we could go to the page ending 0014, and I'll just take you through some of the content of this draft. I accept what you say earlier, or acknowledge what you say earlier about not having any independent recollection of reading this or what was communicated to you orally in the meeting, but I'll come to some of the specific content shortly.
So I have a different number. I see. Sorry.
That's all right. It is attachment B to the,
That's 0011 on the top and 0014 below it. I'm sorry.
oh, your document has two numbers. Yes, that occurs sometimes. You just described the process of a proposal or a briefing coming through the junior minister, and we're about to go through a number of the versions of the draft. What role did you have to play as the junior minister in response to Mr Morrison's request of Ms Campbell?
A junior minister in a portfolio would be working with and encourage their department, and this is a slightly unique situation to the extent that the portfolio contains two separate departments, standalone departments, would, as I said, encourage and work with the department to produce the material that had been requested in response to the Cabinet Minister's meeting with the Cabinet Minister, with my secretary, and I would expect that to include engagement with my staff, with me from time to time, but overwhelmingly the work is done within the department and led by the appropriate member of the SES.
That is to whomever the secretary delegated the primary task, if not performed by the secretary.
Yes, except that the delegation becomes to a degree obvious because of the various policy area responsibilities of the members of the SES.
Yes. The question of policy in terms of ministerial responsibility, that is your ministerial responsibility, was conferred by administrative arrangement orders at successive periods.
Yes.
And you refer in your statement to policy responsibility for implementation. That's something that you understood from the responsibilities conferred by the relevant administrative arrangement order at the time.
Broadly speaking, so the delivery of the payment system,
Yes.
those sorts of delivery aspects, yes.
And did you understand that responsibility to extend to this particular measure in the sense that it created, not only ultimately was it a budget measure, but because it emanated from the department and related to the calculation of overpayments for recipients of social security benefits?
Yes, because compliance and integrity were core business for the Department of Human Services in the making of payments to ensure that the right people were being paid the right amount. People were not able to defraud the Commonwealth if they set out to do so, and that where incorrect payments were made, no matter where the error lay, that they could be corrected.
And the use of the word integrity relates to either overpayments or deliberate fraud in that sense.
Yes.
It seems to be used generally by the department as if it were interchangeable with accuracy, Ms Payne, is that right?
Commissioner, I've not seen it used in that way in the context of my preparation with these documents for this Royal Commission. Accuracy is on both sides of the coin for both the recipient of the payment and the department as the issuing body.
It's just that generally one wouldn't think of correctness of payments as being a matter of integrity, which most people would see as something else altogether. But it seems to be used quite freely in all this material.
Commissioner, I think it may be when the accuracy of payment relies at least in part on the recipient providing their details as to their circumstances to enable the payment to be accurate. And when there is certainly a cohort that's referred to in these documents, a cohort of people who don't do that, then accuracy and integrity can in fact be directly linked. But I have not seen all of this evidence, and so I don't want to speculate any further.
Thank you.
Thank you.
In your experience as Minister for the department, were you aware that there were also administrative errors or administrative inaccuracy in the delivery of social security payments?
From time to time, yes, because the department is staffed by over 30,000 people, and they are not free of human error,
That's right. And at least
all of us.
accuracy was used in that sense to
Certainly.
describe the delivery of payments on the part of the department.
I would believe so, yes.
Senator Payne, this is the first iteration of the potential new policy proposal which has been identified by the Commission. If we could go, if the second half of the page could be called out, please. If I could take you to the subparagraph B. The description here is that the customer would be presented via their online account with information obtained from the ATO and an assessment of their correct welfare entitlement based on this information. That was said to use income smoothing methodology to apportion a customer's income over time of employment, brackets, rather than the current cumbersome process whereby the department has to determine and apply income on a fortnightly basis. Now, if I just pause there, did that passage in the brackets reflect your understanding as Minister about the method by which the department would calculate income for the purpose of identifying an overpayment? That is, it was done by calculation of income according to fortnights.
I think, Mr Gregory, given the period of time since I was specifically dealing with these issues, I could not go to my specific view at the time, and as I said, I don't recall and have not signed or annotated this particular document, but broadly speaking, there was a labour-intensive process of DHS staff who were doing the compliance work that is being addressed in this policy area. And I think it would have been correctly described as cumbersome in that way in terms of the time and the complexity of the process.
To gather evidence which identified in any given fortnight when a recipient received income, received an income support supplement, what their actual income was.
That and their circumstances. So, as you know, I'm sure from these discussions, benefits change if you're partnered or unpartnered. They change if you have dependent or non-dependent children. So there is a lot of material which recipients of payments have to keep current, if you like, or to maintain the currency of, to ensure that payments are accurate, and that the Department of Human Services has, over time, worked to also ensure the accuracy of that.
And the obligation on the customer, as you described, to keep information current related to the fortnightly entitlement or the entitlement on a fortnightly basis according to the satisfaction of the income support supplement criteria.
Broadly speaking.
Broadly speaking. And did you understand, again in broad terms from that process, that the calculation of the debt related to whether that entitlement was satisfied in any given fortnightly period?
I can't now say whether I specifically turned my mind to the fortnightly nature of the process. I received an incoming brief as the Minister, which set out for me in detail the arrangements through which the Department of Human Services did its business. If I could put it in those rather colloquial terms, I received regular briefs at the beginning of my tenure from the senior members of the executive. That's normal for a new minister. And then as updates are required or changes are made, and that change would include the appointment of a new cabinet minister in this case, those briefs may also be updated through that process and those engagements. So that is the basis upon which you learn about the administration of a department, its operation, the acts for which it's responsible, and how it intersects with other agencies.
Do you recall, acknowledging your earlier answers, but I'll ask you directly, do you recall a discussion about a new method by which the department would approach the question of non-compliance in the meeting of 20 January 2015?
Not, I think, in the way that that meets the question. I've made notes, as you can see, for the 20th of January on a number of issues which you read out. None of those go to that aspect, and I can't now say whether there was a specific discussion at that time of those issues in that meeting.
The only other features that I wish to draw to your attention at this point are set out in subparagraph D, and that is the specifics of the proposal in terms of numbers. If subparagraph D could be highlighted, please. Should be there on a screen if you're not able to turn it up in hard copy, Senator. There is a note here that it is a 4-year measure to undertake 866,857 interventions for customers at risk of undeclared or underdeclared income, and the anticipated would result, or anticipated that this result would result in an estimated 1.2 billion gross savings in debt due to returned outlays. I appreciate that this department dealt with some big numbers. Do you recall when you first learned of the proposal that might return more than $1 billion in gross savings?
I would say I recall generally that it was a significant savings measure. I don't have specific recollection of the numbers, but obviously reading material for this Royal Commission has listed those numbers for me.
Can you now say that as a significant savings measure, it had a degree of attractiveness to a government that worked with a view towards a balanced budget?
I can't say that. I can say that on both payments, so outlays, and on savings, the approach that I understood to be a priority was to ensure that we were paying the right people the right amounts of support when and where that was necessary, avoiding paying the wrong people, avoiding fraud, and ensuring that where payments were made in the wrong context or where fraud occurred, that we could recoup those savings. And that was important to the entire budget, yes, but also very important to the job that we did.
What you have just described, would you say that or characterise that as government policy, or just part of core business that you considered to be part of the role within the portfolio?
Paying the right people, yes. I think I would probably want to reflect on my on my remarks. That's the value of Hansard in my professional experience, but I think broadly, yes.
We could go to Exhibit 2171, CTH.4700.0001.2356. Thank you. Ms. Payne, this, I'm not sure of the number in your bundle, but it is the executive minute B15/65.
It's number 18 in mine. I don't know if they're all the same.
And in mine, Commissioner, thank you.
There are some dates which are relevant here. If we go to the bottom of the first page, we can see 23 January 2015. This appears to be drafted by Ms. Golightly within a few days of the meeting on 20 January 2015.
Yes.
Received in the top right corner by DHS-DLO on the same date. And can you confirm that the DHS-DLO was the departmental liaison officer in your office, that is, an employee of the department positioned in your office to assist your ministerial functions?
Yes, that's correct. That's a standard approach, and I had 2 departmental liaison officers in my office.
And to avoid any confusion, they are not advisors in the sense that that also might be used to describe people within your office there.
No, not at all. They are departmental officials who work within the Minister's office and assist the smooth running, if you like, of the management of material between a department and a ministerial office, back and forth, engagement with senior officials, that sort of thing.
Yes. And the stamp just reflects the process of record keeping about when it arrived.
That's correct. This is a physical record.
Yes.
But there is also a digital record, an online record.
Are you aware of whether that's described in shorthand form as PDMS?
In a number of the documents that I've read that have been made available also refer to something called Slipstream. One of those will certainly be part of the management tools that form the online process. And there are other names as well, but I can't recall them now.
The fact that it was received in your office by the departmental liaison officer in hard copy on 23 January 2015 doesn't mean that you read it that date.
That's correct.
And we can see if that in the large box underneath the called out portion that you signed the document on 30 January 2015, and there is a note that you discussed it on 2 February 2015.
Yes, that's my handwriting.
If that called out passage could be retracted, please. Now, the typical form of a briefing to you from the department adopted what appears at the top of the page as recommendations with options for you to sign according to the position that you adopted after reading the document. They're described here as noted or please discuss.
That's right.
The first 2 dot points refer to the meeting on 20 January 2015 and the revision of the draft that we saw earlier. It seems signed by Ms. Golightly on 15 January 15. Paragraph 2 commences as requested. The department is now preparing 2 separate briefs for Minister Morrison, and it continues. that appears to attribute a request to you in that earlier meeting. Is that how you read the document, appreciating you don't have a recollection of it?
I don't have a recollection, but yes, that is how I read the document. And I assume, Mr. Gregory, it's a request by me. I think if it was a request by my office, it would note that.
The division of the briefs was that the first would concentrate on the department's current approach to protecting integrity and options for strengthening those arrangements. The subsequent paragraph deals with a second brief, but that's not relevant for present purposes.
That's how I read that, yes.
You read that? All right. Can I take you to the page in the top right corner, which is the draft brief to the Minister for Social Services, Appendix 1, .2358 are the last 4 digits.
Yes.
The options for strengthening integrity and compliance are set out from paragraph 2 and following. Paragraph 3B refers to the one that is of relevance here. You agree with that?
Yes, I believe so.
That is, it's described there as a systematic clean-up of existing error and non-compliance, Operation XXXX2. And paragraph 5 identifies the potential considerable savings of Operation 2, to use the shorthand.
Yes.
If I can take you then over to the page 2359 to paragraphs 7 and 8. There was a flag here for the possibility of legislative and policy changes for some of the options listed in the attachment, and the indication that DHS was dealing with DSS on those proposals. The second sentence indicates that some of the proposals may have fundamental impacts on social security policy and legislation and would come under, and that it would be expected that they would come under significant scrutiny as not being consistent with the overall beneficial nature of social security law. When you received this document, did you attribute the reference to fundamental impacts on social security policy and legislation in paragraph 7 to any individual measure identified in the subsequent part of the document?
I can't now say whether I made an attribution of that nature or not when I received this document, and as we can see, we know that this is a document clearly that I dealt with, signed, annotated, but I can't say specifically. I'm sorry, Mr. Gregory.
That's all right. If we turn then to attachment A, and particularly paragraph 7, or point 7, which commences 2365. It'll be a few pages over.
Yes.
Should have 8 of 14 at the bottom, yes.
Yes.
This was the systematic clean-up as it was described. Again, you were able to confirm from your review of the documents and notes that you made on this draft, and we'll come to those shortly, that you did read through the draft closely and correct aspects of language that you liked or disliked.
So, yes, so I think what we have here is one, and there are a lot of documents, so excuse me. I think what I have here is one which I would describe as a clean copy and one which is the annotated copy.
And the clean copy is in the form that you received it in your office before marking it up.
Yes, so I did, that's correct.
Yes. The relevant content of paragraph 7, would you agree, is a proposal in the first dot point that would introduce a new approach to reconciling information declared by a customer to the department with information from the ATO.
Yes.
Secondly, the new approach related to an analysis of PAYG files from the ATO for 3 financial years, which are identified as 2010 and 2013.
That's in the second dot point, yes.
Second dot point, yes. That number 866857 appears again, and the estimated overpayment figure is described in this version as just over $1 billion.
Yes, again in the second dot point.
In the second dot point, yes. The third and fourth dot points deal with some practicalities about the approach. The concept of, or the phrase of income smoothing, which appeared in the draft, that is B1539, prepared 15 January 2015 by Ms Golightly, are not repeated here. But again, that might not be something you noted if you hadn't read the document on 20 January.
I see that they are not here, that's correct, but I don't recall specifically identifying a difference between the documents.
The detail set out there describes, in broad terms, a customer having the opportunity to address information presented to it on an online portal. That is, that the obligation was on the customer to ensure the record was correct and provide evidence.
I can see that, yes.
Did you understand that to be a departure from what in broad terms you understood to be a cumbersome process?
I think if I can provide some context, that we're at the point also of significant transition to online services in this period of government. The government had set up, I can't remember whether it was an e-government task force or an e-government group, but a group of that nature, of which, as Minister for Human Services, I was a participant, a member. And we were identifying opportunities to enable an easier digital interaction for recipients of payments. This is part of that, but also a continuation of the long-term engagement and very long-term engagement that the Department of Human Services had with the ATO over many years. Sharing of information, data matching, as it's referred to. And these were all occurring at the same time. I think it's fair to say. Not sure I can take it further than that, Mr. Gregory.
The reference in the second dot point to the financial years 2010 to 2013, was that something that caught your eye in terms of a proposal which was going back in time to deal with potential overpayments which had not been addressed in the financial year or soon thereafter?
I think where it points out the significant number of customers with, as I'm quoting from the paragraph here, with likely incorrect payments at over 860,000, and the estimated size of that overpayment, that would always come to a minister's attention as a significant issue to be addressed, yes.
Yes. If the passage called out on the screen could be withdrawn.
Did it register with you, though, that it was a proposal that would go back retrospectively?
Yes, I believe so, Commissioner, but because it was, as Council has said, it was data from the ATO from 2010 to 2013.
Did you notice anything odd about the figures? By which I mean there are 866,857 customers, of whom 185,396 are said to have incorrect payments in more than 1 year. So logically, that would mean there would be more than 1 million interventions, because some of them are double ups, but we're still at the 866,857 interventions figure at the top of the next page. Did you inquire into how these figures were arrived at all?
I can't recall specifically, Commissioner, whether I inquired at the time, but what I would say is that the language in the second dot point identifies 866,857 customers and talks about interventions for customers in the dot point at the paragraph on the next page, on the first dot point on the next page. So one customer, as you say, may have multiple interventions or more than one intervention, but it doesn't add to the number of customers, if that makes sense.
Yes, but the number of interventions should rise if one customer has more than one intervention. It's just that there seems to be this movement from customer to intervention as if they were identical that suggests a bit of looseness with the figures.
Commissioner, I can't now say whether those figures are, well, you used the word loose. They are figures which I had seen before, so numbers in the 800,000s in terms of customers who may have received incorrect payments, and whether that was described to me as at the time as customers or interventions, I can't now specifically recall. I'm sorry.
Right, thank you.
There are 2 points I wish to take up with you from the whole of paragraph 7. The first is this seems to be something new in the sense that it hadn't been raised with you by the department over your time as Minister from September 2013 up to this point.
I haven't not been asked to examine all of my available material for that period or the documents.
Yes.
So I can't really say to you that I had never had this raised with me before this point. No, I can't say that to you.
Are you able to say you don't have any recollection, given the passage of time, of it being raised with you prior
That's
to
correct. Yes.
this period?
I don't have a specific recollection, and I have not examined any material which would assist me in refreshing my memory for that. I
understand. The third dot point, or the last dot point of paragraph 7, which is the third on page 2366, refers to the possibility of policy change. What did you understand, or what would you have understood a reference to the need for policy change to refer to?
In general terms, I would say it's my experience that it's not unusual when a department is advancing propositions for a budget or for that are in response to suggestions for reform or review, that they may advance suggestions that require either policy change or legislative change. That would not be unusual in my experience. In this case, without a specific recollection of this discussion, that is the context which I believe I would have seen it in.
That is, that this was a proposal being advanced which fell into that broad category of requiring some policy change. But as to the nature of that policy change, it's not something that you, from your reading now, recall identifying at the time.
That's correct. And I would say that this document, which is, as we said, dated in the second last week of January, it's fairly early in the process in terms of its development as well.
the development of the process, that's the development of the process of identifying, well, one, answering the minister's questions,
Minister Morrison,
Mr
yes.
Morrison's questions as they are described at the
Yes.
commencement of the document, but doing so with a view to the potential development of a new policy proposal which might be included in the budget, the May budget.
So my notes, which as we said before, had an annotation in the column which said NPP, that is the only information I have to remind me of the circumstances at the time, but given the development of the documents and the subsequent documents, yes.
In your experience, the timeframe that we're talking about here, late January or mid to late January through to a May budget, is that a tight timeframe for the analysis of a new policy proposal which is in its early stages?
We would have been typically, in my experience, ministers would have been working with departments on budgetary proposals from the back end of the previous calendar year and into January. This was coming forward in January, so later than perhaps other proposals. And as it transpired, I think there were tens of initiatives for DHS and the portfolio in that budget. So this is later, but not extremely late. I've seen much later.
The numbers of proposals being considered at this time, did that, in your experience, reflect a degree of consistency with ordinary pre-budget business for the department, or did it reflect an increased number?
This was my second budget, as I recall, as a minister, and from that process, this seemed a reasonably solid amount of business, yes.
I'll ask that you turn to attachment B, which appears at page 10 of 14 and following. Attachment B is described in the draft minute on page 1 of 14 as the current arrangements to maintain the integrity of welfare payment outlays. That's really the first part of the question to be answered by Minister Morrison. You see in the box at the top of page 1 of 14, item 3. No, sorry, it won't be up. I'll just take you back. You can see the page numbers at the bottom of the document.
Page 1 of 14?
That's it?
Yes. Oh, the recommendations box?
Yes.
Right, sorry, yes.
No, that's okay. And item 3 describes what attachment B is.
Ah, yes,
That's all
I
I'm
see.
directing
Sorry,
your
I wasn't
attention to.
following. Yes,
Yes.
thank you.
And that was relevant to one of the requests of Minister Morrison.
Yes.
And if we return then to attachment B, the relevant passage about the current arrangements commences at paragraph 12 on page 11 of 14, entitled Detecting and Correcting Customer Error in Welfare Programs.
Mm-hmm.
Having read this document in preparation for your evidence, Senator Payne, is what's described there consistent in broad terms with your recollection? That is, from paragraphs 12 through to 20. And you may certainly take your time and read through those paragraphs now.
Thank you. And I'm sorry, Mr Gregory, your question? I've reread the paragraphs.
Is what's described in those paragraphs consistent in broad terms with your recollection of the arrangements as they existed at the time?
I think so. I may have added or subtracted slightly, but broadly speaking, I probably would have included an observation that the very nature of the supplementary payments that we use in our social welfare system regularly increased complexity for customers, that the system that we used, the IT system that we used was extremely old and most definitely described as cumbersome, and made it difficult for both recipients and for the department itself to do these tasks. I would have added that, I suspect, if I was writing it myself. And then certainly, because we do have a means-tested system in Australia, which is very comprehensive, it does depend greatly on the recipient identifying the position in which they are in.
In respect of that last observation that you make, Senator Payne, in most cases of income support payments, the identification of the position a recipient is in is done on a fortnightly basis. That is, the department's informed by the recipient on a fortnightly
We've
basis.
discussed that, yes.
Earlier in your evidence, you've identified that the information you gained about the workings of the department was not all in one lump sum at the start, but it developed over time. Yes. If I can take you to paragraph 16, perhaps 15 and 16. The word cumbersome is used elsewhere, but what is described here is, in paragraph 16, is the traditional compliance review, which is manually staff intensive. And of course, at the end of paragraph 15, there is identified what you described as the IT systems, which were complex and historical.
Yes.
The balance of paragraph 16 identifies that the ability to change the process is due to legislative and policy constraints on the need to apply income fortnightly to determine overpayments, even if they occurred over several months or years, and even if income data is only available on an annual basis. And the example is given with annual information provided to the ATO. If you weren't previously aware of that level of detail from your time as a minister, do you accept that your state of knowledge as at the time that you reviewed this document, but would be informed by paragraph 16?
Yes, and I would like, I'd say, Mr. Rivera, I said I can't identify my state of knowledge as to when I acquired that awareness.
Yes.
But certainly, yes, the specifics that are set out here are part of the that. Yes.
If we turn then to document CTH.4700.0001.2372, Senator Payne, this is the marked up version of the same document, and it might appear immediately after the clean document in your bundle. Or it may not.
thought it did too, but no, I can't. Yeah. You want to go to your question, Mr. Gregory, and I'll see if I've got the right document. I'm sorry.
There is a document on the screen which shows...
I do.
Yes, thank you. In your statement, you indicate, as I read your statement, and correct me if I'm wrong, that the markings on the document reflect markings you made prior to signing the document on 30 January 2015.
They're certainly in my handwriting, and based on the dates, that is my assessment, yes.
There may be some uncertainty about that date because of discussions that you had in respect of this minute on the 2nd of February 2015.
So that's correct.
Yes.
However, I think taken together, that is around the time across those, what would that be, 2 or 3 days?
2 or 3 days, yes. A number of the documents correct grammar, sorry, a number of the amendments correct grammar, and a number change language or emphasis. Would you agree with that?
Yes, I would.
And do they reflect a close reading of the document by you?
Well, I am known to correct errors in my professional approach, but I'm also known to annotate in this way after reading a document. Yes.
A correction by way of example, which reflects both grammar and intent, I suggest appears at paragraph 3B in the second last line. Crossed out those all around the country, that they could be next, and you've put that in more direct language, that is, you're next.
In relation to fraud, yes, that's right.
Yes. In respect of attachment B, that is, attachment A, which appears at page 8 of 14, paragraph 7, the systematic cleanup, you don't, on this copy of the document, appear to have made any corrections or changes. No, paragraph 7 on the previous page.
The copy I have is clean as well.
It's clean as well.
Mr. Gregory.
Does that mean that you didn't identify any corrections that you wish to make?
I can't now say.
Right.
I'm sorry.
We move forward from the date you signed the marked version, that is 30 January 2015. You indicated earlier that there was a meeting on the 2nd of February, that's Monday the 2nd of February, with Ms Golightly. The document is 2504, Exhibit 2504, MPA.001.001.0066. This is the electronic calendar entry.
Yes, that looks like a telephone meeting to me, Mr. Gregory.
Thank you. Henry.
Was my acting chief of staff at that time.
Yes.
My chief of staff was on leave.
That's Megan who was referred to in the previous.
My diary tells me that Megan,
Yes.
that my chief of staff was on leave, and that that was my acting chief of staff.
The reference in the first line to Melissa will phone, or Melissa will phone CPO.
Commonwealth Parliamentary Offices. That's my office in the Commonwealth Parliamentary Offices in Sydney.
Thank you. The record that you made of the meeting is Exhibit 2505, MPA.001.002.0092. You've noted in the first line, Secretary semicolon MG Melissa Golightly again.
MG is Melissa Golightly, yes.
Secretary, does that indicate that the Secretary, Ms Campbell, telephoned into the meeting?
I can't actually now identify that from my records. It's certainly not clear from the calendar entry, and I don't think it's clear from my notes, so I'm not sure. I'm sorry.
The earlier record that you made in your notes tends to identify who was present and involved in the conversation. Could you at least say that?
Yes, I have used that sort of shorthand before. I would also say that Ms Golightly did, on occasions when Ms Campbell was on leave, also stand in as acting secretary. And it's just not clear to me from the records that we've been able to provide to the Commission what exactly was the circumstance here. It may have been that Ms Campbell was on the call, may have been that Ms Golightly was acting.
In practical terms, it was one of those two options, which is indicated.
I would believe so, yes.
Yes. Thank you. The relevant part that you have referred to in your statement appears towards the bottom with inverted commas cracking down. You see that?
Yes, I can.
Now the phrase or the entry that you made, inverted comma, cracking down, inverted comma, dash, what can we do, W/O, having to legislate. W/O is without.
Correct.
And did this reflect what you identified earlier as a large crossbench in the Senate and challenges to legislation passing?
So I think that whole discussion, including the previous reference to under-30s measures and how we can get through the Senate on those, reflects the nature of the Senate numbers and the legislative environment at the time, yes.
You're not able to say, I take it at this point, whether this entry related specifically to the previous entry, the under-30s measures, or what had been identified in the PAYG clean-up as a potential discussion about legislative
not from my
change.
shorthand notes, Mr Gregory.
But what it did indicate was the current state of the Parliament, particularly the upper house.
Yes.
Have you been able to identify, just before I move on, the concept of cracking down as it related to the under-30s measures, as opposed to, say, welfare fraud?
So I would say that I have not specifically been able to attach it to any measure. And I would say, again, that this budget process was bringing forward tens of measures from my agency and across the social services portfolio. And I don't think it's helpful for me to speculate at this point because I don't have a specific memory of that.
I'd ask that Exhibit 2172 be displayed, CTH.4700.0001.2386. Senator Payne, this is Executive Minute B15/92, and the end result is a little out of sequence, but the start of the process appears to be the next step after the meeting on 2 February, because at the bottom of the first page you can see the date under Ms Golightly's name is 3 February 2015.
Mm-hmm.
So to recap, the sequence is a minute prepared by Ms Golightly, 23 February 2015.
January.
Sorry, correct. January 2015, marked by you as being signed on 30 January 2015. A discussion with Ms Golightly or Ms Golightly and Ms Campbell on 2 February 2015, and then a further draft of the executive minute to the Minister for Social Services,
Which is this one that you...
which is this one
yes.
here, yes.
That is the chronology that we've identified as the documents have come forward, yes.
There are two versions of this document, it seems. The one which is attached to this as the annexure, commencing page 2388.
Yes, I have that.
Have that?
Yes.
And again, as I read your statement, you identify that the handwritten notes on the document were made by you in the course of your review of this draft.
Sorry, I can't turn the page. Overwhelmingly, yes. There are actually a couple of points which don't to me look necessarily like my handwriting, but scribbling little notes in tiny writing, it's quite possible they are, but overwhelmingly they are mine, yes.
Can you,
Perhaps an advisor may have annotated the brief on its way to me, is the point I'm making.
is the point that,
But they're overwhelmingly mine, yes.
yes. And if someone else did annotate the brief, do I understand your last answer to be that it was done on the way to you rather than the way from you back to the department?
Yes, well, probably. But again, I don't have a specific memory.
Would it be uncommon for an advisor to mark up a brief that you had already signed? And
Yes.
yes, all right. The systematic clean-up remains effectively unchanged in this document, would you agree?
What page are you referring to?
I'll go to page 2397. In fact, there is a relevant change. I should draw it to your attention. It's page 10 of 16 in the middle at the bottom.
Yes, so I'm on page 10 of 16 or 2397.
Thank you. The last dot point strengthens the language in respect of what changes might need to be made. You'll recall that earlier there was a reference to a change of policy. What now appears in the last dot point here is an additional sentence between the first and the last. That is, the DHS has also advised legislative change would also be needed to implement this initiative.
DSS.
Sorry, did I say DHS? Thank you. DSS also advised. Firstly, Senator Payne, it was, in terms of the division of the responsibility for legislative change advice, as between DSS and DHS, the responsibility of DSS.
Yes, so yes, in the large, or in the general, I should say, there are certain acts which are administered by the Department of Human Services, but not acts which would go to this.
Yes. I think that the acts specified in the administrative arrangement orders, which might fall under the DHS,
Are very, very small.
there's a Medicare Act and a couple of Centrelink Acts,
And the Child Support Act.
and the Child Support Act. Thank you. When you reviewed this document on or about 11 February 2015, do you recall what reaction you had to the strengthening of language about the need for legislative change to implement this potentially significant measure?
I don't specifically recall a response to that change or to that language. I have annotated the document elsewhere, as you have referenced. But again, I would say, Mr. Gregory, that in my experience, that advice in a brief to say that that may be required does occur from time to time, depending on the nature of the proposals, and so would not be out of the ordinary as such. And
I'm sorry, I didn't mean to cut you off.
sorry, Commissioner, I was just going to say, it also advises ministers, and this is the revised draft for Minister Morrison. It also advises ministers that the departments are working together on the proposal and will continue to do so, which is an important assurance, if you like, to ministers that that collaborative approach is being taken to the work that is required. I'm sorry, Commissioner.
Oh, don't be sorry at all. But I was just going to say, can I point out that the very first document we considered, the first iteration of the policy proposal, which was 3784, CTH 3784001004 at 0014, which we might get up, please. 0014. And if you can bring up the last paragraph on that page. I'd also raised this question of legislation specifically in relation to the smoothing notion. Did you make anything of that when you originally saw it?
So, Commissioner, I think I said to Mr Gregory when he asked questions about this document that it's not signed by me, it's not marked by me, and I don't specifically recall now whether it was presented physically to me in the meeting that discussed these issues or not. So I'm not sure.
Not sure whether it was raised with you at the time, this prospect of legislation at that stage.
And my notes don't reflect that, as far as I can see from the notes that we identified, which is, it's a notebook. It's not a verbatim or transcript record. Does not reflect that either way.
All right, now having broken things up there, Mr Gregory, is that a convenient time for morning tea?
Yes, it is. Thank you.
All right, we'll come back at 10:02. Thank you.
All rise. The Commission stands adjourned until 11:50. Royal Commission is now in session. Please be seated.
Mr Gregory?
Thank you, Commissioner. If we could return to Exhibit 2172 at page .2397, Senator Payne, this was the page that we were on, 10 of,
Which page, Mr Gregory?
10 of 16 at the bottom and .2397 in the top corner. This was the document noted as signed by you 11 February 2015, the draft brief to Minister Morrison. It may be at tab 24.
Yes.
You have that?
Sorry, yes.
Just before the break, you indicated that it wasn't unusual for a brief such as this to note a requirement for legislative change for a measure, just as it was not unusual to note a need for policy change for a measure. And you also noted that DSS or DHS was indicated in this paragraph to be working with DSS in respect of those aspects of the note. In a practical sense, if this measure did require legislative change, that couldn't occur prior to the May 15 budget, would it?
No, it could not.
And to the extent that there is a reference in that last dot point to the continued discussions between DHS and DSS about that aspect, if you go back to page, the very first page, that's the briefing to you
Yes,
that you've signed on 11 February 2015,
yes.
you can see there that there is a note that the department's continuing to work with DSS on the proposals contained in the brief there as well.
Yes.
Do you recall communicating to Ms Golightly or Ms Campbell in the course of this process that anything that did require legislative change could not be advanced as a proposal for the May budget?
And I'm sorry, can you repeat that question?
Do you recall communicating to Ms Golightly or Ms Campbell in the process of the development of this brief for Minister Morrison that if something required legislative change, it really couldn't be included in the budget?
No, I don't recall that at all.
At all. Do you expect that would have been obvious to the Secretary and Deputy Secretary of the department?
I'm not sure what you're putting to me. I'm sorry, Mr Gregory, with that question. Because it is often the case, and I can't remember out of the 30 plus proposals which came through the portfolio, perhaps more, to this budget, how many needed to be brought forward in legislation. I can't recall that number. But I wouldn't have had as a standing view, to the best of my recollection, that we couldn't present a proposal that required, we wouldn't present a proposal that required legislation, if that's your implication.
Yes, that's what I'm getting at. Would a matter be taken to the Expenditure Review Committee, subcommittee of Cabinet, if it required legislative change, irrespective of the limited prospects of obtaining legislative change given the state of the Senate?
As someone who was not a member of the Expenditure Review Committee or the Cabinet, I can't speculate on whether there was an unknown approach that they had as entities. I'm not aware of that at all. And in fact, after the 2015-16 budget, if I was to examine the record, I'm sure there would have been measures that required legislation across government that had to be taken to the Parliament. So that would be most unusual to me.
All right. That is, the prospect of legislative change didn't prevent a barrier at this point in the development of the proposal to the point where it was advanced to the ERC.
Not that I can recall.
Can I just ask you this? Whom did you understand the proposal to extend to? In other words, current welfare recipients, prior welfare recipients, or both?
The proposal to strengthen compliance had a number of facets, which I'm sure has been discussed, Commissioner, that included addressing what you might call hangover debt, and the briefs that we're talking about today refer to that. But it also has in prospect changing, addressing future compliance from current and ongoing and new recipients of payments.
Okay, but what came to be referred to, I think, as employment income matching, and the notion of extending back to 2010, you'd have appreciated would have involved people who are no longer on social security?
Potentially, yes,
okay.
who had, in the assessment of the department and from the material that the ATO had provided, potentially had a debt for incorrect payments to the Commonwealth.
Yes, thank you.
The version of the document we're looking at now, signed by you 11 February 2015, is noted, is it amended over revised iterations?
Several
Yes.
iterations, and I apologise for my handwriting.
Not at all. One of those iterations is Exhibit 1268, CTH.3008.0008.4321. It may be behind tab 23.
Yes. Yes.
It's again signed by you on the same date, 11 February 2015, but the amendments include at page 4331, that's 9 of 18, marking through what was paragraph 5, new data sources, as a duplicate of paragraph 3, which was on the preceding page 4330.
I can only presume I did that, but yes, that is what has happened there.
Yes, which brings what is paragraph 8, originally numbered in this version of the document on 4332, on page 10 of 18.
Yes.
To paragraph 7.
Yes.
And that suggests on its face that these amendments were made prior to the one that we were looking at before the break, which had the PAYG clean-up at paragraph 7. Even though the cover sheet of both documents is signed by you on the 11th of February 2015, it seems that one was done earlier on that day or the preceding days. And,
Actually, yes.
and in your statement, I think you identify that you were shown an email from Melissa Golightly internally within the department which indicated some feedback by you and revision of a minute from which you inferred that there had been a revision by you of the draft on the 10th of February.
You mean I was shown in these documents
Yes.
through this process? Yes, I've
Yes.
seen that email, yes.
Yes.
I would not normally have been privy to those
No.
sorts of emails.
No. But it tended to confirm the sequence I just
Yes,
identified.
thank you.
The final version of the document, that is B15125, prepared for Minister Morrison, is Exhibit 2029, behind tab 25 in your bundle, Senator Payne, CTH.2004.0002.2506, and you can see that it's a total of 17 pages according to the numbering at the bottom of the first page. But I'll just get you to check that on your copy.
Yes.
And as indicated at the top of the first page, it's to the Minister for Social Services for action and to you for your information.
Yes, I can see that.
Yes. And this document was forwarded in its final form to your office on the 12th of February 2015.
That's what, this is the DLO stamp on the document.
Yes, if we go to Exhibit 2068, CTH.4700.0001.2404.
Yes. Although,
That appears to be the document already signed
yes,
by Minister Morrison with a date of 20 February 15, although the stamp to your office is 12 February 2015.
and at this point I can't account for that time difference or that stamp. I cannot, and I would not necessarily have seen that either at the time.
No, can I just clarify with you the process in terms of your experience at least?
Yes.
Am I right in understanding that 2 copies of this document would have been produced by the department, one for your office and one for Minister Morrison's office?
Most likely, yes.
At some point, this signed copy from Minister Morrison's office makes its way to your office, but that may form part of a record-keeping process rather than being returned to you by him, so you're aware of what's going on.
Yes, I would say that in my experience, I would have thought a signed copy of this would be passed from the departmental liaison officers in the Minister for Social Services office to the departmental liaison officers in the Minister for Human Services office, in this case mine, when that was signed. But as I said, I'm not sure how that sits with the date stamp and the signature block, or the signature and date.
In the preparation for your evidence, has your attention been drawn to an email from Ms. Kate Ridderhoff, a departmental liaison officer in your office, dealing with the exchange of the minutes between Minister Morrison's office and your office, or Minister Morrison's office and the department?
I don't believe so, Mr. Gregory, but if you can point me to it in the papers, I'll have a look.
Commissioner, if it assists, that was a document we were only provided with this morning, so the Senator hasn't had a chance to review it.
I'm sorry, I didn't get the last part of what you said.
So the Senator hasn't had a chance to review this document.
Oh, well, perhaps you'll get one now. Thanks.
Where is that one, Mr. Gregory?
In my bundle, it's behind tab 37. Is it an email commencing, "Hi Marg"?
Yes.
Okay.
Yes, I can see the email.
That's okay. I'll just ask that you take the moment to read it if you haven't had that opportunity. Is exhibit number 2515, CTH.3053.0016.0749. The email reflects some confusion about whether it was B15/125 or 126, which was forwarded as the attachment.
Ah, yes, I see.
But the critical part of it for present purposes is at the bottom of the page, the indication that the signed brief for progressing to Minister for Social Services was being developed in hard copy in a morning's courier run and allocated in a slipstream, which I think was an electronic process you identified earlier. The middle, as you read that, and as you have referred to other documents, that appears to suggest the brief was prepared on the 12th of February and forwarded to your office and Minister Morrison's office that day.
I'm not sure that that email trail, Mr Gregory tells me that it was sent to Minister Morrison's office in that process that's set out in this email.
All right.
But I don't know all of the names in the email, maybe, but it doesn't tell me that immediately. All right.
That's okay. The second aspect of the email which is apparently relevant is the last email in the trail. It's sent 23 February 2015. This is at the top of the page.
Yes.
Describes Minister Morrison as signing B15/125, and there's an attached scan. And the second sentence notes that Minister Morrison has kept attachment B, hence only pages 1 to 11 of the brief have been returned.
Can see that?
We return then to Exhibit 2068 behind tab 26. This is the signed version of the document with the signing date of 20 February 2015, again indicating pages 1 to 17 at the bottom of the first page, although the document ends at page 11 of 17, consistent, it seems, with that email that we just referred to.
Yes, I see that.
Yes. That is, the attachment B is missing from it. The final version of the document at page .2413, that's 10 of 17.
Yes.
Reflects in substance the various critical features of the proposal that had been developed through from meetings on 20 January through to 12 February.
Yes.
Particularly the number of interventions in the third last dot point are the same, the estimated gross savings of 1.2 billion are the same, the need for policy and legislative change are identified in the final dot point. Those are all features which were present in different forms of language, perhaps, but present in earlier versions of the document.
Yes, it's my recollection.
And the indication there is appears to reflect that Minister Morrison signed the pursue option in respect of that item.
That's what this says, yes.
All right. Can I take you forward to 25 March 2015 in time? You will see behind tab 27, I think, Exhibit 2506, that is MPA.0001.00001.0058. This is an ERC briefing entry in an electronic calendar.
Yes.
ERC is Expenditure Review Committee, the subcommittee of Cabinet, and various attendees are identified there. Catherine, is that Ms Campbell?
That is the Secretary, yes, Catherine Campbell.
Melissa Go-Lightly.
Yes.
The other attendees?
Other deputy secretaries then of the Department of Human Services and my Chief of Staff.
Megan.
Yes.
From the documents that you have reviewed, you have identified that the Expenditure Review Committee met on that date.
Yes.
That is later that afternoon.
That's correct.
And considered the proposal, which was item 7 in the executive minute to Minister Morrison. Or rather, I should say more accurately, considered a new policy proposal which reflected item 7 of the executive minute.
The ERC meeting, which we've now confirmed via the records I was invited to attend, considered the whole brief of the social services portfolio for the 2015-2016 budget,
Yes.
of which there were, to my recollection, and it's not clear to me, had access to documents, supervised access to documents to assist in preparing for the Royal Commission. I think there are tens of those, more than 30 proposals, and that was one of them, yes.
Yes. I could take you to tab 28, Exhibit 2022, PMC.001.0002.017. I think this highlights what you just said about the volume of material. It's described as an attachment or attachments to Cabinet submissions. Attachment A contains a subheading summary of all new policy proposals. Attachment A3 is strengthen the integrity of welfare payments. And at the bottom right corner, you can see this is page 1 of 364.
Yes.
That is, there were 364 pages of
Material
attachments
associated.
to a Cabinet submission
Yes.
relating to a number of...
Yes, an ERC submission, but it's described as a Cabinet submission, yes.
Yes. The relevant pages, if we go to the second page, which is page 6 of 364, under the headings there, we see in the middle of the page, strengthen the integrity of welfare payments, and there are projections across our financial years in respect of savings and expenses. See that?
Yes, I do.
The material content of the measure is attachment A3, as was indicated on the first page, and it appears in this extract in the following pages, which at their bottom right corner are numbered 20 through to 26.
Yes, I can see that. Yes.
There is the proposal description in broad terms on page ending on page 20 of 364. And again, I understand the effect of your evidence to be that although you attended the Expenditure Review Committee for the consideration of the DSS policy proposals, you are unable to say if you reviewed this document.
That's correct, Mr. Gregory. We, on the material available to us to prepare for the Commission, have not been able to identify any documentation that has been provided through any of the processes that indicates that my office or I were provided with copies of the NPPs, including this NPP. And I'd say in terms of my experience and the context for that, that the Department of Human Services was not the lead department at the ERC. The Minister for Social Services, the Department of Social Services are the lead department at the ERC and Minister at the ERC. And we are asked to attend to assist effectively if required, if questions are asked of us. in relation to proposals. And in all clarity, I cannot now tell you, after some 9 budget cycles as a minister, whether I participated as a contributor to the ERC or just attended it. I do not recall whether I was asked questions or made any comments.
Would you need ordinarily to be in a position to answer questions if they were asked when you were
About a policy
invited?
position, yes.
Yes. Does that suggest that the usual process would mean that you are provided with the 364 pages of attachments?
Not necessarily as a junior minister. That would not necessarily be the case. And we have endeavoured to determine whether I was or was not, and have not been able to identify that.
I think you indicated earlier that your attendance is by invitation.
Yes.
Is that the invitation of Mr Morrison?
No, that is the invitation of the chair of the ERC.
What would, in your experience through budget cycles, be the basis on which the chair of the ERC would invite you in this particular circumstance?
It may be the case that the Cabinet Minister suggests that a junior minister is also invited to attend. It may be the case that the Cabinet Office or the Cabinet Secretary suggests that a junior minister in a portfolio is also invited to attend. May be the case that the Treasurer's Office or the Prime Minister's Office suggests that a junior minister be invited to attend.
There are a range of relevant persons who might indicate that your attendance is potentially helpful or desirable.
That's correct.
Do you recall any conversations with Mr Morrison about whether he thought your attendance was potentially helpful or desirable?
I don't recall any specific conversations of that nature.
Was it, to your recollection, a practice that you as the Minister for DHS and he as the Minister for DSS would confer in respect of upcoming budget proposals?
So I don't think you can describe it as a practice, because Minister Morrison was appointed in December of 2014.
Yes.
And this was the first budget during that period. His predecessor minister, Mr Andrews, I worked with on proposals for the preceding budget as well. And I think it is a fair assessment to say that every Cabinet Minister has a different approach on these matters.
Do you
And
recall?
what was Mr Morrison's approach, as far as you could tell from your exposure to him?
Where he was not concerned and indeed comfortable with my participation in these processes.
But what about working on proposals together?
It doesn't, if I can say, Commissioner, I wouldn't describe it as working together on proposals, because the departments overwhelmingly do the work that sits underneath the production of the material and the briefs and the information. In that way, it's not a case of I'm not sure what the appropriate comparison is. I'm sorry, but it's very much material generated through the departmental process, senior officials. But you'll see, I think, and we've gone to my records to provide as much information to the Commission as we could about the meetings that you requested my meeting history and records on. And there are no meetings in this period of time, for example, that I took with DSS officials in the preparation of, in the doing of this work. So it is kept quite separate in that way.
All right. The only reason I referred to working with the Minister on proposals is that's what you described doing with Mr Andrews, I understood.
Yes, I'm not saying we did not work together. I didn't mean to imply that. It has to be colleagues who are advancing the proposals, but it's not, again, if I was to search my diary, if the relevant discussion here was about meetings with Minister Andrews and his team on these things, I think it would reflect the same circumstance.
Wouldn't it be extraordinary if a new policy proposal which entirely depended on implementation by your department and was in which staff of your department were heavily involved in the preparation of it. If you didn't see it before it went to the ERC?
I would say, Commissioner, given the volume of material that was involved in the budget process, that there would be potentially a number of items that I would not necessarily see as a junior minister. And I have endeavoured to assist the Commission. I cannot find a record, and we cannot identify a record. None of the material which comes from the Commonwealth identifies a record of a specific review of the NPP. Now, clearly, there is the records that we've discussed with Mr Gregory this morning in terms of the briefs that go to the development of the NPP, but not the NPP itself. And my recollection now from 2022 to what I did in 2015 does not let me tell you the answer to that question, I'm sorry.
Well, the question wasn't whether you did. I'm just asking you, wouldn't it be extraordinary, given that it was a policy proposal which concerned your department, both in terms of its preparation and its implementation, if you did not see it?
Well, if there are 30 plus NPPs, maybe even 40, and they are across a wide range of work of the department, and some of the meeting records which we've tendered to the Royal Commission indicate the breadth of that work, it may not be that every NPP, which is not in my name, it is in the Cabinet Minister's name, does not end up coming across my desk.
And how usual was it that the policy proposal would come from the senior minister when it did concern the junior department entirely?
Well, the senior minister in the portfolio is the minister charged with taking matters to the ERC.
So whatever the proposal,
Yes, that's correct.
it would go through him.
Sits in their name. So an example would be, for context, as Defence Minister, I would have had a number of assistant and junior ministers within my portfolio who may have advanced proposals concerning defence personnel or other defence matters, but they would go in my name.
All right. This was a proposal which you'd been involved in the development of, in the sense that you had been so involved in the preparation of the minute, which gave rise to it. So you knew a good deal about it. You'd looked at
Yes.
material. And you were being asked to go to the ERC. Would you not have wanted to familiarise yourself with the proposal before you did that?
Commissioner, if you have, and I'm sure you have, seen the first iteration of the statement that I made, it was my thinking that that had been the process. However, there is no material available on the record which indicates that, and we have provided a supplementary statement. One of the reasons that I said that in my first statement provided in November was that as a Cabinet Minister subsequently and for the last 6 years, that was most certainly my role and certainly what I did. And I think, and using that experience, we responded to the question of the Royal Commission in that way. Subsequently filed a second statement, as you would be aware, which indicates that we don't have a record, that there is certainly no record to say I approved an NPP.
Right. But you do seem attentive to detail, if I can say that, from the notations we've seen on the executive minute. It would be remarkable if you didn't look at the policy proposal, wouldn't it, when you were attending Cabinet about it? Something that you'd been involved with?
I can only repeat what I said, Commissioner. That was my initial sense, but we have not been able to identify.
I appreciate that you haven't found the documentation of it, but do you say that it would be unremarkable for you to turn up at an ERC in this kind of context without having looked at the proposal?
Well, I think what I said in my previous response to Mr Gregory and to you was that, to your point, given that I had been involved at points of the process prior to that, including the finalisation of the brief to Minister Morrison in February or March, I can't recall which now.
February, I think.
12 February, yes.
In February, because I had been involved in that process, I was familiar with it and versed in the detail of the discussion. So I understand the point that you are making, Commissioner, but I can't assist you.
All right, thank you.
For completeness, on the day that the Expenditure Review Committee met, you have reviewed your diary entries
Yes.
and you've identified that the 8:30 meeting, which we've seen on the screen,
Yes.
is an entry there. That is an ERC briefing session with the DHS Secretary and Deputy Secretaries, and your Chief of Staff was scheduled. At 12:30, an ERC preparation meeting with the Minister for Social Services was scheduled. I'm referring here to paragraph 10H of your second statement. Might be tab 3.
Yep. Just going backwards, I'm sorry.
No, that's okay.
Yes.
And at approximately 4 p.m, the ERC meeting occurred.
Yes.
It looks as though the day was set aside for ERC preparation from those entries.
So they would be meetings that occurred between sittings of the Senate and other meetings. So the 12:30 meeting would, for example, be a meeting that takes place just before a minister's period of preparation for question time. Question time being reliably at 2 o'clock every day. Most ministers would spend time prior to that preparing, whether they're cabinet ministers or outer ministers, junior ministers. So that 12:30 meeting would have preceded that. We seek leave from the chamber to be paired in the parliamentary system for a meeting like a cabinet meeting or an ERC, so that if the chamber divides, we're not required to leave the room at an inconvenient time.
But again, there was time made available at the least for preparation for the ERC, which included on the face of the diary meetings with the DHS Secretary and Deputy Secretaries and Minister Morrison.
Yes.
In reviewing the new policy proposal as it's contained in Exhibit 2022, back to tab 28. Have you identified any meaningful difference between the proposal as it was worked up by the department and incorporated into the executive minute to Minister Morrison and this document?
Mr Gregory, this document, if I recall correctly, was provided to us very recently. I think I saw it for the first time this morning.
Right.
I have seen one of the copies that is screen only, but it's slightly different from this document at one point.
That might be an earlier draft of a new policy proposal.
It might be, but I have not had an opportunity to
All right.
compare this to other documents
Okay.
in detail. Sorry.
If we could go to page 22 of 364. This is a continuation of what's described as the policy case.
Yes.
The second paragraph commences analysis of one source of information, which identifies over 800,000 individuals. An earlier time period with which you were familiar, that is the 2010 to 2013 time period.
Yes.
The proposals, at least in a package, aim to ensure individuals and others are unable to avoid being more actively engaged with their obligations. And if we go down to the bottom half of the page, there is the description of the introduction of an online approach by which customers are required to electronically confirm the correctness of DHS information or information DHS has obtained. There is the phrase, this acknowledgement will include a statement notifying the customer that they will be committing an offence by failing to provide accurate information.
I'm sorry, can you tell me where you are, Mr Gregory?
Below the redacted portion, that is in the first paragraph below the redacted
Yes,
portion.
I found it, thank you.
Yes, it's the last sentence of that paragraph. That addition hasn't appeared in any of the iterations of the 12 February minute. Do you recall, or have you been able to identify at what point that was introduced?
I don't, no.
The proposal or the new approach continues. Targeting historic overpayments is the dot point due to incorrect income declarations. And there is the reference to the PAYG file, the obligation being on the customer to ensure their record is correct, and the removal of the significant regulatory burden for small business that is required under the current approach. The second sub-dot point commences, the new approach will not change how income is assessed or overpayments calculated, but it will enable the department to undertake a significant clean-up of potential incorrect payments for 866,857 customers for the 2010-2013 financial years. The policy continues with some detail, and if we go over to page 23 of 364, at the bottom, implementation and delivery is set out. It's to commence 1 July 2015, with the implementation of the task force and other elements would be implemented as follows. Increased analysis of PAYG data commencing 1 July 15, using existing business processes, and from 1 July 2016, the increased PAYG analytics work, transitioning to the automated system. Having gone through that detail here now, that appears to be entirely consistent with the proposal as it was developed for the executive minute.
Yes, without comparing page to page, yes.
Page to page. The number of interventions are the same.
Yes.
The financial years are the same. The basis of the comparison of information and calculation of debts are the same. What doesn't appear there is the suggestion that there would need to be legislative change or policy change to introduce the measure. Now, from your experience, if that remained the position of one or both of the departments, as was expressed in the executive minute, ought it to have been included in this document or as a relevant consideration by the ERC?
I would expect so, unless there had been a change of view, that would be material which was included.
The description as it appears here contains some inconsistency with the executive minute as it was developed and in its final form in that second dot point or sub-dot point on page 22, which asserts the new approach would not change how income is assessed or overpayments calculated. Again, having gone back through the process this morning of identifying the various descriptions of how the new online process would work, there was a very clear link between a new online process and the calculation of fortnightly income by reference to PAYG data, which might be over an annual period. You'll recall that.
I recall that discussion, yes.
Yes. And this asserts an inconsistency with that in the sense that the new approach would not change how income is assessed or overpayments were calculated. You can see that there.
I can see the statement, yes.
Yes. Do you accept, having read it now, there appears to be an inconsistency between that assertion and what was developed in the executive minute?
So, Mr Gregory, I would say subject to the fact that I'm dealing with a redacted document,
Yes.
and so there are blocks of text that I'm not able to read, and whether that gives any context or not. I do acknowledge, absolutely, not having had a chance, as I said, from when I saw this for the first time this morning, to do the comparison with previous documents, that I don't recall that statement as part of previous documents.
But more than that, it appears to be inconsistent, doesn't it? Because the material for the executive minute had indicated that there would now be reliance on ATO data, annual data, to assess income.
Well, the ATO, Commissioner, the ATO relationship with the Department of Human Services is a very long one, but I think the point, if I may ask you, I think the point you're making is about annual data.
Well, the use of ATO data as the primary basis for assessing income was clearly a new development.
Well, yeah.
And that's what the information being put to you was.
So the relationship between the ATO and the Department of Human Services for the purposes of making assessments, and in fact, the 2010 to 2013 numbers come directly, as I recall, from that, the ones that are referred to at the top of page 22 of 364. That is through the ATO-DHS relationship.
Sure, the ATO provides a gross amount of income as determined from the PAYG data, and the department looks at that as against what's been declared and says there's a discrepancy, we'd better investigate. But it hadn't previously been suggested that the ATO data would then become the basis on which income was assessed in the way that was suggested in the material leading up to the executive minute, that it would be a primary trusted source. You'll recall that there was reference to the possible need for legislative change to allow the use of the ATO data in that way.
The references to policy and legislation, yes, I do recall.
All right, so there clearly was a change in the way that income was to be assessed if ATO data was to be given any status.
I don't think I have access, Commissioner, to the sort of documentation that would have showed the processes between the Department of Human Services and the ATO to understand that in detail, but I accept the point that you're making on the face of it, that is what has come through these briefs, yes.
Okay, so there does seem to be an inconsistency, would you agree?
The reason I find it difficult to answer that question in a yes or no sense is because of the redactions, and I don't know what else the document says, Commissioner.
Well, you can proceed on the basis that the redactions were made because they weren't relevant to anything that was part of the Robodebt scheme. In other words, they weren't relevant to that part of the strengthening the integrity of the welfare system proposal, which actually concerned employment income matching.
Okay.
So you needn't worry too much about there being some hot information there that you're missing.
No, it's not hot information, Commissioner. I was just thinking about context.
All right, so back to the original proposition that there's an inconsistency between saying that there's no change in the way income is assessed and what had been presented in the material leading up to the brief to the Minister, which was that ATO data would be used. And as a minimum, I think the documentation said this would involve a change of policy, and at points it was said that legislative change was needed.
I agree, yes.
All right, thank you.
In that context, did you inquire of Ms Campbell in the scheduled meeting at 30 on 25 March 2015. What happened to the concept of legislative change and policy change for the measure?
Mr Gregory, at this point, I don't have a specific recollection of the discussions of that meeting, and we did endeavour to see if I had taken notes at that meeting, and there are none in my notebook. It would have discussed, though, the whole
Yes.
of the tens of initiatives that were part of the DSS portfolio submission. Not just one.
It's not just one, I appreciate that, but there are a number which were directly relevant to DHS, and this was one of that number.
I have no specific recollection, I'm sorry.
And I don't understand you to suggest that because there were lots of proposals that your level of detail dropped off in your preparation compared to, say, if there was only 10.
Well, the proposals went across the remit of the Department of Human Services, which is broad and, for example, goes from, as we discussed very briefly earlier, issues to do with Medicare, payment thereof, with child support, Australian Hearing, and with these matters as well. But I don't now recall, almost 8 years after that meeting, what was specifically discussed that morning.
Do you recall, even in general terms, any discussion at any point between February and March, this date, about what happened to the clear advice that legislative change was required to implement the proposal?
Don't have a specific recollection of that, and we have examined my notes for any relevant meetings.
The exhibit which records your attendance comprises two exhibits: 2507 PMC.00.0054.001 underscore
Yes.
R. Attended earlier today is the Expenditure Review Committee attendance record. The date in the top right corner is Wednesday, 25 March 2015, and there are various categories of attendees, and towards the bottom we can see co-optees dash Chief of Staff and Secretary. You can see that?
Yes.
Your name appears in respect of item 5A only. The Departmental Secretary, Ms Campbell, her name appears in respect of item 5A only. And does that indicate to you that Ms Campbell was also present in the Executive Review Committee consideration of this new policy proposal?
Yes, that is what that indicates to me.
You've just turned back a page, and for completeness, is that a document entitled Expenditure Review Committee Second Revised Business List?
Yes, it is.
Not yet tendered, Commissioner, but I do tender it. It would become Exhibit 2507 capital A.
Yes, it's admitted with that number.
Thank you. I understand it's in the system. I'll just confirm it on the screen with you, Senator Payne.
Somebody's noted a number on mine, which is PMC 00100109004R. That looks like it.
That's the electronic version of the copy that you just turned to in the material before you.
Okay.
And what we can see is that it relates to the ERC business list for the afternoon, and it has item numbers, and item 5A is the 2015-2016 budget for social services, and A is the portfolio budget submission and finance green brief. Now, the portfolio budget submission, is that the 364-page document?
In the absence of the document, that would be my assessment, yes.
Yes. And the minister responsible is Mr Morrison. I think you indicated earlier that that's because he's the portfolio minister, so all the proposals are produced
By the Cabinet Minister?
by the Cabinet Minister. Effectively, he's the proponent of the measures.
Yes,
Co-optees is the column in which your name appears.
yes.
What does co-optees mean in this sense?
It means the outer minister or the junior minister of both, and Senator Fifield and I were both outer ministers or junior ministers in the portfolio, are co-opted for that item. A note that, as you mentioned, Mr. Gregory, and I think this is an example of the fluidity of these meetings in some ways, that although my name is listed beside 5B as well, the record says I did not attend for 5B on the next page.
Yes, that's right.
Only
What might be drafted earlier in the day is not always what happens in practice,
That's correct.
but that doesn't detract from the attendance record you identified
No, not at all.
as being there for
And I
5.
didn't intend it to do so.
No, I'm just clarifying. One of the documents considered by the ERC is described as the Finance Green Brief.
Yes.
If we could go to Exhibit 2508, PMC.0001.0010.8842. It's a document which runs for many pages, but we go to page 17, finishing .8859. Senator Payne, you can see that page 17 and page 18 of the document relate to this particular measure.
Yes, Mr. Gregory?
In the left column, there is the item for consideration, and that is what was described earlier as the strengthening the integrity of welfare payments. Portfolio budget submission, and there's a number with attachment A3, and you might recall that from the earlier document that I showed you, the largely redacted one.
Yes.
Right. Again, this is a document, in your experience, which is prepared to focus on the financial aspects of the measure.
Yes, this document is prepared by the Finance Department for the Finance Minister and for the ERC.
And the left column highlights financial aspects of the proposal.
The items for consideration column?
Yes, that's right.
It does both a summary of the policy aspect of the proposal and the financial aspects, although the middle column, in my experience, is where finance put the numbers
Okay.
themselves.
The summary can be read there in the items for consideration column. The next page, which is page 17, to complete that column, sorry, page 18, identifies who will be affected. There is a reference there to 866,000 people, sorry, payments, at the same period of the financial years. That reflects what was contained in the earlier document.
Yes.
All right. And the right-hand column, if we can go back to page 17, is the finance comment. The bold passage, if that could be called out. Is that the Department of Finance did not support the measure at the time. Is that a fair indication of what is communicated there for
Yes.
the reasons set out?
Yes.
And the reasons relate to the evidentiary basis for the costs and outcomes of the proposal.
I would, Mr. Gregory, also say, in addition to that observation, that the subsequent paragraphs go into further detail of the finance department greens, as they're known.
Yes.
And then, as you see, it lists the Prime Minister and Cabinet department position as well. And the process by which the greens are produced is, in my experience, from not from the sort of detailed material that the Department of Human Services or the Department of Social Services in this case would have to hand. It is literally on the papers.
If the called out portion could be withdrawn, the first of the items below that to which you referred commences the upfront cost. This identified really what was being sought by DHS to implement the proposal in the upcoming budget, the figure
Yes.
of $280.5 million
Yes.
over a 4-year period.
Correct.
And the estimated savings were in the order of $1.1 billion, which the comment notes may or may not be realised in forward estimates.
Yes.
Had you had any involvement in the estimates, that is, in terms of outlays and forward savings for this measure?
I can't specifically recall my involvement at the time,
Yes.
but between agencies, so between the Department of Human Services, the Department of Social Services, Department of Finance, certainly senior officials would have been involved in that to and fro process, which is extremely intense in the preparation of any budget. And from time to time, department officials may advise ministerial staff, whether that would be in the Office of the Minister for Social Services or in the Office of the Minister for Human Services, of the status of those negotiations. And as we also see in the documentation for the Commission, there's also formal correspondence between the Cabinet Minister and the Finance Minister as part of that negotiation process as to costs and how that is often restructured from the original NPP proposal to what Finance, for example, is prepared to agree to and what the ERC is prepared to agree to.
Or inclusion in the budget.
Yes.
Completing that topic, are you able to say from your review of documents that the question of what the Department of Finance agreed to for inclusion in the budget was an issue which was resolved following the ERC meeting in the lead up to the budget?
The correspondence that I have had the opportunity to review suggests to me that that is the case, yes. I can't specifically say that from the green at all, but the correspondence suggests so.
Other documents to which
Yes.
you've referred. The second paragraph below the bold passage, if that could be called out, refers to the recovery of incorrect payments made in 2010 needs to occur during the 2015-2016 year in order to avoid the statute of limitations applying to the collection of debts arising from these payments. Did that, when you reviewed this document, it may be very recently, prompt any recollection about that topic back at the time?
No, it didn't, and I can say that it is often the case in an ERC process that a junior minister won't have access to greens.
Yes, if that document can be taken down. Senator Payne, moving forward in time from March 2015 and the May 2015 budget, you became aware of criticism of the scheme in January 2017, even though you had moved to become the Minister for Department of Defence, the Minister for Defence.
Yes, as I've said in my statement from media commentary, I think, at the time. Or it may have been also the parliamentary estimates process, but a combination of commentary of some sort.
Did, to your recollection, that cause you to reflect on how this process had developed in 2015?
Not that I can specifically recall, because I would say, as you say, on reflection, that having left the portfolio only 4 months after the budget for a measure in terms of the details that we're talking about, that was not going to commence in its application until the 1st of January, the 1st of July, the next year, 2016. And I had not particularly turned my mind to that, to the best of my recollection, in terms of that commentary.
Moving forward then from January 2017 to late 2019, you became aware, no doubt, of a government announcement about cessation of raising debts pursuant to the Robodebt scheme. And in 2020, perhaps about May, became aware of a government announcement that refunds were to be made for debts raised under the scheme. At that time, did you reflect upon how that process evolved as an introduction to budget measure, which effectively introduced a process or gave funding for a process which raised debts without a sufficient legal foundation?
Certainly in terms of the impact that was being described at the time on individuals or families who had been subject to the operation of the scheme when it was implemented, and I think others have said before me that its implementation was less than perfect. Certainly that impact was clear for me and for others to see, yes.
But the review of the documents that we've gone through today, and I appreciate you wouldn't have had those documents when those government announcements were made or had access to them, identifies that the basis on which legislative change was required to introduce the proposal, and I'm talking now about the final version of the executive minute, related to what was described in earlier versions of the executive minute as the calculation of fortnightly income by reference to annual PAYG data, which you may appreciate was the basis on which the announcements were made by the government in 2019 and 2020.
I'm sorry, your question is?
The question is, how did the identification of the problem in the lead up to the final executive minute drop off the radar by the time, it seems, the Executive Review Committee considered the proposal?
Expenditure Review Committee.
Sorry, the Expenditure Review Committee, yes.
Mr Gregory, I don't know the answer to that question, and I say that in all transparency. The material which has been made available to me is material that I have been through for the purposes of appearing here today. But in terms of that particular matter, I don't know the answer to that. Clearly, there is an expectation, however, that when agencies advise you on the face of a brief that they are working together to address these issues, and that is specific in that paragraph about policy and legislative issues, that the officials are doing that, as it says. The process for bringing the NPP an NPP is accompanied at the rear of the documents, and I think there is one here, which is called the checklist, that refers to a number of aspects of the formal cabinet processes, if you like, or committee processes.
Can I just interrupt you there? Not to stop you answering the question, but just so the document can be brought up for you to complete your answer. It's Exhibit 2022, PMC.001.0002.017, page 27 of 364. The last page. That's what you're referring to?
Yes, it is.
Yes.
There are checks through that process as well, and I don't recall, and obviously I have spent some time since the request for the notice for material came to me from the Royal Commission, some time examining the material available to me. I don't recall any formal advice on even the nature of the policy and legislative changes which would need to be made coming to me as the Minister for Human Services. That would not normally have been the remit of the Department of Human Services, but I did not see any other advice that I can recall on that matter either. And as you say, the change between the briefs that preceded the NPP to the NPP, we have endeavoured, and with the assistance of my legal representatives, endeavoured to identify any material which would shine a light on that, and that has not been evident. So I am dealing with what is before me and trying to assist the Commission based on that.
Do I understand part of your answer to say that although you can't explain how the issue dropped away, that you would expect the Department of Social Services to brief its minister as the portfolio minister on the detail of the legislative change and policy change identified in the executive minute?
No, I'm not speculating on what the Department of Social Services would or would not do. If a department took a decision to advance that matter to a minister, then I would expect a brief to be generated. And it would not matter what the department was. And I have the ability to provide a comparison to other portfolio responsibilities I have had. And I would also say, Mr. Gregory, in relation to your previous question about my reflections, moving from human services to both defence and foreign affairs, which are significant portfolio responsibilities. Was not my habit to step back, if you like, into another portfolio area, and I was not asked to do so.
Are you suggesting that it is, well, let me just ask it in an open-ended way, in respect of the policy and legislative advice identified in the executive minute necessary to introduce the proposal, whose responsibility is the preparation of that advice at that stage?
In this preparatory
context,
briefs?
Yes.
Yes. My observation would be that they are high-level references. They do not say, for example, you need to amend the Social Security Act, or you need to amend the Income Tax Assessment Act or the Privacy Act, or any of those things. All of those paragraphs that I have reviewed seem to me to say we are working together on this. I only have access at this point to briefs from the Department of Human Services. I have not seen any briefs from the Department of Social Services in preparation for this. I would expect the agencies to work together.
It is a shared responsibility in that respect.
If they are saying to their ministers that this may or will, and I think the language does actually change, require policy or legislative change, then yes, there is a responsibility borne in both departments.
Does that mean that the responsibility is also borne by both ministers?
Essentially, responsibility is always borne by ministers.
And in this case, it would be safe for you to assume, I suggest, that by the time the executive minute reaches its final draft and says there may need to be a change of policy and there will need to be a change of legislation, even though the specifics are not identified, you would expect that someone has identified the specific basis before they advance the general high-level proposition.
Not necessarily, if I may say, because the part of it is, if you want to change a policy approach, if the next question is that policy approach dictated by legislation or by the policy of the government? That can be answered in the general before the specific. And so it's not clear to me at all from this material, and I do not recall being the recipient of any brief on this matter, that there was ever specific advice provided to ministers who, as I said, are ultimately responsible but must receive advice from their departments.
What about your position when you were getting these draft briefs? Would you not say to the Secretary of the Department who's given you this brief, what kind of legislative change? What are we talking about here?
Commissioner, I think at the stage at which the process was, and the last brief, if I recall correctly, was a February brief to Minister Morrison, not necessarily have asked for specifics at that point, no.
We've already heard about the delicate situation in the Senate. Wouldn't it have been a fairly burning question to know what would be involved if you had to go down the path of legislative change?
Well, as Mr Gregory asked previously, until you actually have a budget passed, which gives you the decision of the Parliament to work with that, the preparation of legislation, in my experience, is not commenced. And Commissioner, I've not, in my experience, operated on the basis of what can I get through the Senate or what can I not get through the Senate in my approach to these matters in any portfolio that I have held. If there is a point of government policy or principle to be pursued, then I've sought that advice based on that desire to deliver a particular policy outcome. And I have also seen the Senate do some extraordinary things in terms of its decision-making over the years. And you can't predict, even based on the numbers that Mr Gregory provided very early in our discussion today of how many people were on the crossbench, 18 I think in total, can't necessarily predict an outcome in March for a budget measure that might be presented to the Senate in August or July or whatever month it might have been. That we see this reported intensely every day as to who can persuade members of the crossbench or the independents to support an initiative. That is the stuff of the political process in the Senate that I'm well used to.
It didn't cross your mind that this might require legislation which would affect retrospectively the basis of assessment of entitlements for social security recipients?
Commissioner, I would have expected a brief from relevant senior officers in my department on a matter such as that.
You knew that it would require the use of ATO data as a basis for determining what income entitlements were, did you not?
I can't go to, I think we've had this discussion to some extent. I don't have a specific recall of all of my recollections at the time, but I have, I think, agreed with you, Commissioner, that that was certainly part of the discussion, yes. And also the fact that the Department of Human Services and the ATO, as evidenced by the example of over 860,000 potentially incorrect payments being identified already, had been working closely together for a very long time.
Yes, but that's a different thing from applying ATO data as the basis for assessing entitlement.
I'm not saying it's not different.
Okay. I'm just asking you, did that not present itself to your mind as a bit of an issue when you're talking about going back 4 or 5 years?
if the advice to government is that there are over 860,000 customers who may have received incorrect payments, that number over $1 billion, in terms of, to go back to the terms we used very early today, integrity of outlays and integrity of payments, that's an issue for integrity of outlays and for the taxpayer.
Yes, but it might also be an issue to say to a social security recipient, we assess your income on the basis of what you declared as your annual fortnightly income, as your actual fortnightly income. Now we're going to take an annual ATO figure and apply that instead.
In terms of the, I guess, day-to-day processes of what DHS officials and the online system asked of customers, as a minister, I would not be writing those or planning those. They would be done, obviously, by those staff who were much closer to the process than a minister.
All right, look, I think it's probably time we took the lunch break, or past. Have we got a mention that's necessary, Mr. Glover, Mr. Scott? Can you tell me?
Thank you, Commissioner. No, I've had productive discussions with Mr. Scott. Dr. Rannick, who proposed the mention, now doesn't require it, but Mr. Scott might wish to be heard on that.
Commissioner, an issue has been raised by the representatives of the Commonwealth and Mr. Morrison. I anticipate that the issue doesn't raise a mention, or require a mention, I should say, but can I confirm that after the lunch break?
All right. Anyway, we're not having one now, that's the point.
No.
2:30, thank you.
Commissioner, I think I'll only be 5 minutes.
I've got a couple of questions, so
Thank you,
I'll take the break. Thank you.
All rise. The Commission stands adjourned until 2:30 p.m. The Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Yes, thank you, Commissioner. If I could have Exhibit 2522 on the screen, RBD.9999.0001.0223. It may be behind tab 44, Senator Payne. It is a printout of a joint media release by yourself and Mr Morrison. You have that? Yes.
I have it, yes.
Go to the page ending 0002, that is _0002. At the bottom of the page, the date is identified as 10 April 2015, so after the ERC meeting. And there are a couple of passages which are identified as relevant for present purposes. There is the investment in IT redevelopment, to put it broadly, in the first part of the page _0003. That is the replacement of the decades-old welfare payment IT system with a modern platform. And the series of quotes includes 5 down. This investment will also help us stop the rorts by giving our welfare cops the tools they need on the beat to collar those who are stealing from taxpayers by seeking to defraud the system. This is in the context of IT systems replacement, I take it. But when there is a joint media release like this, is that something that your respective, that is the Minister's respective media advisors confer on, or do you have input into it directly?
Mr Gregory, I can't speak to this specific press release, but I can speak in the general, which is to say, yes, that would usually be a matter for input from both officers, and to the extent that they're available, both ministers. I think it is important to note that this, as it became known, Whippet, but the Welfare Payment Infrastructure Transformation Project was commenced under the previous minister, by me, under the previous Minister for Social Services, Mr Andrews. It was certainly taken through first pass before Mr Morrison was appointed. But yes, we would both officers, no matter who the ministers were, would usually have input into a release like this.
The next passage of relevance is at the bottom of that page and the top of the next page, commencing improved data sharing, and
Yes.
the top of the next page, this means customers. It appears that this is specifically attributed to you. Is that how you read it?
Yes.
And is that because you would expect that you were consulted directly about this language?
I can't speculate, Mr Gregory, and I have no specific memory of this release, but I know that other releases have been provided to the Commission which indicate that one of the matters which we pursued in government, and I pursued as Human Services Minister, was the question of defrauding of the Commonwealth and the taxpayer, frankly, in relation to people who tried to do that within the social welfare payment system.
And the pursuit of that goal by the government included what appears to be referred to here as the measures introduced in the May 2015 budget.
Yes, that's true, and it's that is the case, and it's not unusual that governments flag through early statements like this matters which are contained in budgets. That happens often.
You would agree with me, though, that there's a difference between those who deliberately or in a calculated way defraud the system and those who receive overpayments because of the complexity of the system and the complexity of reporting arrangements.
Yes, and I hope I've been clear in saying that today, that there is definitely a difference, yes.
This joint media release appears to lump everyone in together. Would you agree with that? The tenor of the comments don't really distinguish between the non-compliance concepts that flow from the complexity arrangements and those who engage in calculated fraud.
I don't think I do agree with that, Mr. Gregory. I haven't had the chance to hear while we've been talking to read every sentence of this, but it does talk about a simpler system that makes it easier for people to comply with requirements, to spend more time job searching, for example. It talks about much of the complexity people associate with claiming government assistance as a result of the red tape created by the ageing system, which is absolutely true. This system will be designed around the customer, ensuring people are directed to the appropriate services for their situation. Now, press release is never a thesis by definition, and so I suspect for economy of expression, you may be left with the impression that you have used, but I don't necessarily agree with you.
By the time 2020 rolls around and it becomes very public knowledge that the scheme it involves significant failures of public administration.
Yes.
And from your review of the documents that you've identified, you would agree with me, it appears that prior to the new policy proposal being before the Expenditure Review Committee, the particular question involving the need for legislative change relating to the calculation of debts from annualised data or average data was identified by the department, but became similar to or almost identical to the basis on which the failures in administration were identified years later. Would you agree that it was the same core issue in 2015 identified in the executive minute and the earlier iterations of it as was identified in 2020 as the fundamental problem?
I don't think that I can say from the executive minute, which said, as I referred to earlier, at a pretty high level, that policy and legislative change, and I would have to go back to check the exact language, but policy and legislative change was certainly referred to at a high level, and we discussed this with the Commissioner earlier in terms of how much detail was not in that, I suppose I would say. So I also don't have the detailed knowledge of the matters that were examined by ministers and by lawyers, I presumed, for the provision of advice in 2020 to really answer that question.
It's not at such a high level. The attachment B talks about the ability to change the process is limited to legislative and policy constraints as a result of the need to apply income fortnightly to determine overpayments. And even if the only income data you've got is on an annual basis. Now, if there are legislative constraints on what you can do because you've got to apply income fortnightly, as it says, that's pretty much where we ended up, isn't it? That fortnightly income was what was relevant, not what you got if you averaged annual ATO income.
As I said to Mr. Gregory, Commissioner, I don't think that I have enough of the detail of what was closely examined in 2020 because I've been focused on considering my period in the portfolio area. I don't have enough of the detail of what was considered in 2020 to respond to that. And I do think that is high level. I would expect significantly more detail in a brief around what was necessary for policy or legislative change, if that was what the focus of the brief was.
The Robodebt scheme must have been a pretty significant issue for the government you were serving in, even if you weren't the relevant minister in 2020.
Yes, I'm not saying it was not.
But you don't recall the details of what the problem was?
I recall the details of the issues that were raised, but I don't have the specific detailed knowledge, I was saying, Commissioner, of the matters which were considered by the responsible minister at the time and other senior ministers. I was in a completely different portfolio area. In 2020, I was the Minister for Foreign Affairs and dealing with a very significant set of issues in the broad of that portfolio on any given day, let alone with the overlay of COVID-19 and its impact on Australia and internationally.
Right, thank you.
Did you understand, though, in general terms, that the issue in 2020 related to the raising of debts without evidentiary basis under the scheme?
Prompted by this process, Mr Gregory, and the material provided or made available to me to examine and this discussion, yes, I agree. Can I reflect specifically on my recollections from 2020 at the time? No, but I agree with that from that perspective.
I suggest you're in a unique position to identify where the process fell down in 2015, given the identification of the need for legislative change in respect of the need to apply income fortnightly to determine overpayments being incorporated in the executive minute, but then disappearing by the time the budget measure is before the ERC.
So I think that I said prior to the lunch break that based on the paragraphs, the relevant paragraphs from certainly the final brief, but also other iterations, which mentioned policy and legislative issues, but also mentioned that the departments were working together, DHS and DSS, on those. My expectation would have been that that work was being done by those departments and would be brought to ministers as needed. That is the role of advice from departments, to be elevated or brought to ministers as needed. And I don't think that I do have that position that you have described, largely because of the shortness of time after the budget at which I left this area of portfolio responsibility for a program that's implementation date was 1 July 2016. So leaving the portfolio in September of 2015, although we have not been asked to go to that, my provision of material up to 30 June 2015, for example, to the Commission, indicates the range of work that we were continuing on across multiple aspects of this portfolio, of the human services portfolio, but does not indicate a particular and singular focus on this one issue.
But nothing that you've looked at suggests that the question of legislative or policy change was considered at all after the Expenditure Review Committee meeting.
Nothing that I've been provided to examine, no.
And you don't have any recollection of any events relating to advice or the question being raised following the Expenditure Review Committee?
I think I said earlier, and I want to be consistent, that I don't have any recollection of receiving advice on those matters.
And looking back at the documents in this process, we can see why that might be the case, because the representation to the ERC in the new policy proposal was that there's been no change to the way income is calculated or overpayments are calculated.
That's what the document says, yes.
The inconsistency that existed between the executive minute and the new policy proposal stands to reason that the question of legislative and policy change disappeared after a representation like that to a subcommittee of Cabinet.
I don't call that a representation to the ERC in that way. The content of the NPP stands on its own, as I understand that process, whether it is on this subject or or other subjects, they will often be the product of preparatory work, such as this, overwhelmingly, in fact, be the product of preparatory work such as this, which goes through multiple steps.
Yes, I might have phrased that poorly. I wasn't suggesting it suggested in and of itself something that was inconsistent with, with an earlier document, but that it contained a position about the measure which we can see now was inconsistent with the position adopted in the executive minute. That's what I was suggesting.
That is the difference, yes.
Yes, and the position adopted in the new policy proposal is the obvious explanation why the question of policy change and the question of legislative change needed for the proposal fell away, because there was no suggestion of that in the new policy proposal.
I think the other matter or the other aspect of this is that there does not appear to have been advice that has been produced as part of this process that indicates why departments, if they did, changed their position.
Because
Advice to ministers, I mean.
I understand that, because that really brings me to this final point, and that is that there are only two explanations really for how the question of policy and legislative change disappeared between Minister Morrison signing the executive minute on 20 February and the Executive Review Committee meeting on 25 March. And that is either, as you identify as a possibility, someone changed their position in respect of advice on the question, or someone just rewrote the words out of the proposal without a change of advice.
I don't think I can comment on that because I don't have any knowledge of that.
But in terms of the two practical options, you would agree with me as a matter of logic, those are the only two options, aren't they? And they assist to identify where the process fell down, which is where I'm getting to. Can you identify any other practical?
I don't have it. No, I don't have anything to add because I don't have any further knowledge.
And in the Commission's search for the identification of advice, let's assume that that possibility doesn't eventuate, that someone didn't provide an advice to the contrary of what's contained in the minute. The other option is, why would it be that someone rewrote the language to avoid the question for the Executive Review Committee?
And I don't think I can speculate on that.
A number of features of your evidence suggest that there was a government interest in the continuation of the proposal without legislative change. They are the attractiveness in terms of the saving measure and the government's approach to a balanced budget. They're the policy considerations that you identify in terms of reforms to the welfare system, of which one part was the policy of ensuring the right people get paid the right amount at the right time. And that includes, of course, questions of compliance. And then there was the short time frame, that is, legislative change couldn't be achieved for the introduction of a measure by 1 July. And then the fourth point, of course, is the inability or the real question mark about the government to get any legislative change through the Senate. And that was a feature which you've identified was on your mind in one respect or another as at 2 February 2015 in your meeting with Ms Golightly. Taken in a cumulative sense, those four features provide an explanation, I suggest, as to why someone in the department would not have given you the advice that you now say you would have expected, but would have rewritten the language to avoid the question.
I think you began that question by saying that there was an attractiveness to government of pursuing this policy without legislative change, but that's not a proposition that I think I have put. I have said that adverting to the briefs, for example, where it did indicate the need for policy or legislative change, and DHS working with DSS, that says to a minister that that is the work that is occurring. And so the desire to pursue both integrity of payments and integrity of outlays, improved compliance, is not for me, was not for me, and I don't intend to represent this in my statements here today, was not contingent upon legislative change or not legislative change. As I've said, it is not surprising to me to see briefs that say to pursue this path, whatever it might be, as a government will need to look at policy or legislative change. So yes, the policy was one supported by the government, or the proposal was one supported by the government, but I don't believe caveated in that way. And in terms of how that progressed from the brief to the NPP and the nature in which the NPP was provided, I think I've, to the best of my ability, to the best of my recollection and to the best of my use of the material available to me, answered those questions.
That appears to identify that there was a shortcoming at departmental level about the adequacy of the advice given to yourself and Minister Morrison.
That is a question that I have asked myself in recent weeks, preparing for this engagement.
And what was your answer?
I think that if my expectation was to see further advice from paragraphs such as that, which said that my department was working with the senior cabinet department, and that did not come to pass, then I've not been provided with or been able to access a reason for that.
One of the questions this Commission has to answer is how maladministration, if I use the word, a failure of administration in this sense, can be avoided in the future. Surely on a scheme of this scale, the answer can't simply be someone didn't do what they ought to have done at some point. Or do you say that is really the answer in this particular context?
I'm not sure that I'm in a position to provide that answer, Mr. Gregory. I have responded to the best of my ability to your questions and to the Commissioner's questions, and to the requests for information from the Commission, to the requests for documents and calendar details. And in doing that for a ministerial period over 7 years, almost 8 years ago, tried to provide as much as I can, but I don't think I can provide that answer to the Commission. I do know, and you asked me this earlier, I do know that the impact of the implementation, and to be clear, the implementation was 1 July 2016.
Well, that was the second part of the measure. The first part was 1 July 2015.
But that was the task force.
No, it was the Manual Online Compliance Program, which adopted the same terms.
I understood I might have to go back to my notes, and I apologise for that. I understood that the actual formal implementation of this part of the scheme was 1 July 2016.
Certainly the online compliance process was 1 July 2016.
Yes.
The department adopted the scheme in a manual sense,
Which was...
in terms of calculating debts from 1 July 2015.
Take a point.
Yes.
I'm sorry, now I've lost my train of thought.
I think you were going to say that you can't predict from the time of March 2015 what is required to change between then and 1 July 2016 in a legislative sense.
Something along those lines, yes.
Would you agree with me, though, that when we turn to the question of the department's advice to yourself for information and to Minister Morrison for action in the executive minute, that up to the time that that minute was progressed to Minister Morrison, the department was very responsive to all of your feedback to it about the content and the language of the executive minute?
In the large part, yes.
And if you'd asked for more detailed information, there's no reason to think that that would not have been provided to you.
I can't speculate on that, but I don't have any reason to think that the department would not have assisted with a request.
Yes, because the other part of the equation when you say, well, you would have expected some more detail around the advice, is that the department might respond and say, well, if the minister wants that, we would provide it, but we don't know that she wants that when we've identified the issue in the minute already.
So if I go back to the iterations of the brief,
Yes.
being advised that work is ongoing, to me says that we'll produce an outcome.
I don't think I could argue with that. That it was before the Expenditure Review Committee in about 5 weeks from Minister Morrison's signing of the document. The question is, how did that outcome change from the content of the executive minute such that legislative and policy advice fell away as questions of relevance?
And I've endeavoured to answer those questions, and I don't have any further to add to my responses. I'm sorry.
But you didn't see the outcome and you didn't go looking for it.
Not specifically in terms of expecting, in terms of further briefs. There are hundreds and hundreds of briefs in any given period, but I don't recall further advice on that matter.
I have no further questions.
I've got a couple. If we could have up CTH 4700 001 2372. This is the iteration of the brief. I think it's one of the earlier ones in February that you've written on at any rate, Senator Payne. And then if we can turn the page to the document ending in 2373.
So, Commissioner, I'm sorry, I don't know
Look,
where
I
you
can
are.
tell you that it's in 18
Okay, that helps me, thank you.
and it's not the first but the second of those copies of the executive minute.
Yes.
So if you go to page 2 of 14,
Yes.
I just wanted to ask you about something you'd written there in relation to paragraph 7, or it's not quite written, but the last sentence is about the proposals. DSS has advised that some of the proposals may have fundamental impacts on social security policy and legislation, and it could be expected that some proposals will come under significant scrutiny as not being consistent with the overall beneficial nature of social security law. And it seems that you've underlined that and put a question mark. You see where I'm
Yes, I do.
talking about?
Yes.
So was it not a view that you subscribed to that social security law had any beneficial nature?
No, that would not be the interpretation I would apply to that. That would be me asking in my own mind for further commentary or information on that point. I was not disagreeing with the point. I was reminding myself, I think, and again, it is hard to retrospectively analyse that, but that would be my view of such an annotation.
Right, and do you know if you got that advice about where it did conflict?
I don't know now, no.
And if we can come over to 2379, I just want to put some propositions to you. That's a couple of pages over at 8 of 14.
7-9?
It's 2379 at the top, 8 of 14
Yes.
at the bottom. Under the systematic cleanup heading, the third bullet point tells you that the customer will be presented with the ATO information and the amount they've declared, an assessment of their correct welfare entitlement based on this information. They get the opportunity to update it before it's applied to their record. Now, if you're going to use ATO income information, would you agree it has to be averaged, as they call it, because you get an annual figure? So the only way to apply it to any income recipient is going to be to divide it by 26 to represent a fortnight if you've got an annual figure. You'd appreciate that the tax office doesn't get fortnightly figures.
Yes, I understand the point that you're making. I can't comment on I didn't mean to write on that, I'm sorry, I'm not sure if I'm allowed to or not. I can't comment on the specific approach that the staff undertaking the interventions took, but yes, I understand the point that you're making.
So we're talking about an averaged income. And we know that ATO data is to be used for this purpose, and that it will, according to this, it'll raise, or the overpayments, just over $1 billion. And then when we get to the new policy proposal, it's not really put in those terms, but perhaps I can just tell you what it says. It's or you can look for yourself, but we may not need it on the screen. It's at 28. It's a bit more coy. I want you to go to page 22 of 364, if you would.
Yes.
It's under the bullet point targeting historic overpayments, and it says that it will target discrepancies based on PAYG information, and it will work on incorrect payments for the 866,000 odd customers for those years. And we're still at this stage talking about recouping $1 billion. So it stands to reason, doesn't it, that when they're talking about using ATO information, they're still talking about averaging, involving averaging, where customers don't come up with different information.
If they're interrogating, Commissioner, if they're interrogating previous payments and previous ATO data to address what broadly I would say were described as outstanding potential outstanding debts because of payment errors or overpayments. As part of that, they were moving to the single touch payroll, and
well, they weren't doing that as part of this. This was, single touch was projected as the future. This is the transition to single touch.
yes, I think that's what I said. Well, I thought
Right.
that's what I was trying to say just then. And this this approach gave the department an opportunity to look at a significantly larger number of overpayments, whether, as you say, they did that with averaged information or otherwise is not immediately clear to me, but I, again, understand what you're saying about the material that the ATO provides.
Yes, and while I appreciate that you don't recall seeing this document, all I'm saying to you is it stands to reason if you've got this proposal to use ATO data and apply it to people's benefits in respect of their entitlements, even if you don't specifically say we're going to average, if you're still going to get $1 billion back, averaging must be implicit, mustn't it?
I'm not sure whether that is the case, Commissioner, in terms of how the information available to DHS and the ATO is structured, and I would be speculating. The work that the ATO did, as I understand it, which led to these numbers, the work that they did for the 2010-2013 financial years, which they provided to DHS as part of this process, is what led to the estimate of the potential size of over. Well, how to describe those? I'm sorry, I don't have the words right in front of me, but of overpayments, I suppose, it's not. I don't recall specifically now what steps that involved.
Okay, but nobody came up with another proposal, as far as you know, to use this ATO data in some way that wouldn't actually be the way that was suggested in the
Not
first
that is
place.
evident to me on any of the material that I have seen or any of my recollections, no, Commissioner.
All right. Then I just wanted to ask you about some of your media releases. And I don't know, do these appear on the system? Mr. Gregory, I don't see Commonwealth numbers on any of them but the one you referred to, I don't think.
I understand that they do, Commissioner.
What I was going to ask you about was, I suppose, tone, really, Senator Payne, in relation to the items that appear in 46, 47 and 48. So if you'd come to 46, and can you help me with where it would be found on the system at all?
It's 46 is Exhibit 2524, RBD.9999.0001.0232.
Thank you very much. You'll see that it concerns someone who has defrauded the Commonwealth, been convicted. And you do say most people who receive welfare payments are honest. But over the page, it's in this context that you then go on, or the release goes on, to talk about strengthening the integrity of the welfare system and the 1.7 billion welfare integrity measure, which is basically the measure that was before the ERC, is the part of which is the employment income matching measure.
Is that did you want me to answer?
Well, what I want to ask you is this putting the measure in a context which will suggest to the public at large that this is really the pursuit of criminals?
So fraud within the payments system, which I saw up close for a period of time, is certainly a very legitimate area for governments to pursue to try to address both the integrity of the payment system, but also ensuring that payments go to people who need and deserve them
Absolutely.
in the right amount and in the right way. And where I saw, as Minister for Human Services, fraud of this nature, and in fact, I have not seen this release for some time until the Commission obviously asked for it or asked for any releases. You don't just have to take my word for it, but the court itself described the offending as prolonged, deliberate, sustained and premeditated. But I've also seen fraud perpetrated by potential participants in terrorist activity, social welfare fraud. I've seen fraud perpetrated by people who would seek to defraud the Australian taxpayer and the Commonwealth by exploiting disaster relief in times of great crisis. And I have seen fraud like this. So I do think, and I believe then and I believe now, that it is important to be very clear as a government in relation to these matters. And as I said to Mr. Gregory earlier, a press release doesn't have the capacity to be a broadly expansive thesis. It's a very brief and concise way of sending a clear message.
Okay, all I'm saying to you is why bring up the budget measure in the context of fraud when the budget measure supposedly was really directed to people who had received overpayments in respect of whom there was no necessary allegation of fraud?
Well, I don't have all of that material in front of me, but I do think the encapsulation of that whole budget in 2015, and I think there is a broader media release to which Mr. Gregory drew my attention earlier. The encapsulation of that budget was on multiple issues within this portfolio area. And in fact, it was not one Mr. Gregory referred to. It's the one headed Welfare, Integrity, Fairness and Sustainability for All Australians, which finishes in, I'm not yet familiar with the numbering system, but it finishes in 0002 in my
All right, perhaps we could get that
brief here at
Is this the
45.
RBD 9999 001 0223 002? Or
0001 underscore 0002, yes. And that refers to a strong welfare cop on the beat, and that is about fraud. And the next paragraph is about an entirely different issue. The next paragraph is about an entirely different issue again.
Okay,
that
if I
was
can
part of
stop
the
you for a
narrative.
minute, I think I gave the wrong number and we will give it up, get it up. It is 9999 002 0001 at 0003. So,
Exhibit 2523.
well, again, here aren't you talking about that measure generally, which is the one that's supposed to recoup 1.5 billion? And you're talking about it in the terms, in criminal terms, cop on the beat, when some of this may be inadvertent non-disclosure. A lot of it, as it turns out, may be debts which actually were wrongly raised, but they're all lumped together. All you know is that you've got, in respect of the employment income measure, it is based on discrepancies between ATO income figures and declared income, but they're being lumped in with this as though you need a welfare cop to pursue it.
I think the briefs that we've discussed at length today, Commissioner, go to the broad of the response to Minister Morrison's request for a range of initiatives in this area, which include, certainly include fraud, certainly include ensuring correct payments to the right people, and certainly include recouping payments made in error, either the error of the person claiming them or of the department in making them. It covers all of those, and as you say, in response to the, the context of the media release that you referred to earlier, that does say most people who receive welfare payments are honest and do the right thing, because that is absolutely the case.
Yes, but this strong welfare cop on the beat just doesn't distinguish.
As I say, a press release rarely goes to every aspect of a full policy.
Okay, and just for completeness, if you would look at the media release at 47, and this is, can you help me with this, Mr. Gregory?
Exhibit 2525, RBD.9999. Is that the one, Commissioner?
Mine doesn't have a number, though.
No, mine doesn't either, Ms. Payne, but it's under 47. Have you found it?
I have, Commissioner, yes.
Jail for welfare fraud. Again, this concerns somebody from Warwick who's stolen 17,000, somebody in WA 95,000, somebody in Warwick again 50,000. And you talk about it being, the last one being detected by the data matching program. You talk about criminal offences. If you're doing the wrong thing, you'll be caught. We've got an obligation to protect the integrity of our welfare system, and then we're on to, and that's why we've announced the 1.7 billion welfare integrity measure. Don't you think that somebody reading that might think, oh, okay, those people who are the subject of the measure are all in this category?
Well, I think the paragraph preceding that, Commissioner, where it says we have an obligation to taxpayers to protect the integrity of our welfare system so that we can ensure that we can support those in need, emphasises the importance of government doing that as well.
Yes, but again, there's no distinction between the people who are the subject of this measure, in respect of whom there's nothing but really a discrepancy identified between ATO declared income and their declared income, for which there may be an explanation, or even people who have misstated their income, but not in any criminal context, there's no distinction.
Well, I would say that that is because the subject of this particular statement, for example, is about 3 different sets of welfare fraud.
Yes, but the welfare integrity measure isn't entirely about fraud.
Not entirely, I understand.
Well, why talk about it in this context? That's what I'm trying to get.
Because this is about fraud. I think, if I may say, the nature of the media release is a short and concise, I suppose, but short, sharp summary. There's a lot more behind that. As a minister for a long time, I would say that if a journalist was interested to pursue the media release, they would usually contact, not this one specifically, but any release, contact the office and would be provided with a great deal more information. This is not all there is to see, if you like, in terms of how that works. And that information would go to the greater breadth of, as you say, the policy of the budget announcement, the measure as it's called here, to provide that information to anyone who wished to write a story about it.
Okay, well, for completeness, the last one's the next folder along, 48. Again, can you help me with that?
Exhibit 2526, RBD.9999.0001.0230.
And it's a very similar thing. It's a $200,000 fraud. You talk about that, and then we're back to the strengthening the integrity of welfare payments budget measure, which is expected to save $1 billion over 4 years. Again, you're talking about that measure in the context of fraud.
And I would reiterate the points that I had made previously. We now have a $200,000 fraud example, which was very sophisticated and ongoing. And to make the point to those who would seek to follow in the footsteps of an individual such as this, the press release enables a very short, sharp message. Behind that, though, there is a lot more in terms of engagement. If a journalist wants to ask for further information, or we offer further information, that is part of this process. But this is about delivering a short, sharp message about someone who would seek to defraud the Commonwealth, in this case, over 13 years with a separate identity. And it's not the case, Commissioner, that this is isolated, unfortunately.
No, but it doesn't bear much resemblance to the sort of person on youth allowance who hadn't worked for an entire year but found their income being averaged over an entire year and got told they had a debt, who was the subject of this budget measure and is really being talked about in the same context as a person of that kind.
I'm not suggesting at all that they are in the same category.
But they were the subject of this budget measure. And one view of this kind of use of media is that it was really designed to give the impression that the people, the subject of the budget measure, deserved no sympathy at all because they were really criminals. Is
So,
that fair?
Commissioner,
or-
that was not my intention, not my thinking, not my approach. But in relation to fraud, and I think these are 3 strong examples, I would be very clear that it can't be tolerated by government.
I don't think anybody would argue with you about that, but as you appreciate, my point is that you've talked about a much broader measure in the context of that kind of case. Well, anyway, I think you've answered, so perhaps we can leave it there. Thanks.
Just before,
Yes, sorry, Mr. Gregory.
that's raised a couple of questions that I'd like to ask. Senator Payne, would you agree with me that by the time of the release of these ministerial media releases, that is Friday 4 September 2015 for the 52-year-old Warwick man who was sentenced the day before, and the release just taken to, which I can't find a date, but plainly before you left the department at the end of September that year.
I'm sorry, I don't understand the question, Mr Gregory.
I can't locate a date on the one that,
No, I can't either.
but it had to be before you left the department at the end of September 2015.
Yes, so the two that appear with my current header on them, which is the blue header, they've been printed off I think probably off a website that provides them with that header, but that's not the header they would have had at the time.
No.
If I can assist, Senator Payne in her statements identify the dates of each of these, and the one that I think my friend's looking at now is the 10th of September 2000.
Interested him. Thanks, Mr. Arnott.
Yes.
Thank my learned friend. These people could not have been caught by the measure which was introduced in May that year, said to commence in a manual way from the 1st of July 2015. That is, they couldn't be identified, investigated, charged, brought before a magistrate's court over any number of occasions and ultimately be pleading guilty within about 12 weeks of the introduction of the measure.
I would have to, no, I'm not suggesting that they were, and I don't think these media releases are either, suggesting that that was all done. What the release, for example, the one of the 4th of September 2015 says, we have an obligation to taxpayers to protect the integrity of our welfare system so that we can ensure that we can support those in need. That's why the government announced a $1.7 billion welfare integrity measure.
The point I'm making is that all of these people were caught under the system that pre-existed the new policy proposal introduced in the 2015 budget.
Yes.
On the other hand, you were issuing these media releases at a time when the online manual compliance system had started, so that if there were people caught by it, there might then be an inference that, well, that's what that measure was for.
It's not my inference, Commissioner.
Thank you.
And just one further point of clarification. Senator Payne, I suggested to you earlier that the first implementation of the scheme contemplated by the new policy proposal was 1 July 2015. If I could have Exhibit 2022 placed on the screen, this is the extract from the portfolio budget submission behind tab 28. And if I could ask that the document be taken to the page 23 of 364. You'll see at the bottom under the heading Implementation and Delivery.
Yes.
I was referring to the first dot point, the increased analysis using PAYG data would commence 1 July 2015 using existing business processes as an understanding of the manual
At cross purposes.
business, yes. And then, of course, the automation rather than the manual process from 1 July.
We're speaking at cross
2015.
purposes.
Yes, okay. It occurred to me, of course, now that I was given more time to think about it, that in addition to the 4 reasons which suggested a need to get this through without legislative change, there was that additional feature identified in the finance green brief of the question of the limitation period, that these debts from that first financial year really needed to be pursued in the 15-16 financial year, otherwise the opportunity to recover the money might be lost. Factoring that into the suggestion that there were a number of motivators to get this through without without legislative change, does that assist you in any way in answering that other question about why people within the department might be motivated to write the proposal in a way which didn't raise these questions between the executive minute and the ERC meeting?
No, it doesn't, Mr Gregory. When you pointed out the statute of limitations matter earlier, I was trying to recall if I had seen that mentioned elsewhere previously, and I had not.
No, I don't think it appears anywhere. But the Department of Finance raised it somehow
Yes.
in the process.
And I had not seen that in any of the material that has been otherwise, that had been made available, or that we have sought.
Nothing.
Ms Hogan-Doran, do you have any questions?
No questions for Senator Payne. Thank you, Commissioner.
Mr Arnott?
No questions, Commissioner.
Thank you. Do you want Senator Payne excused, Mr Gregory?
Yes, Commissioner.
Thanks, Senator Payne. You're excused.
Thank you, Mr Gregory.
Mr Scott will take Ms Taylor.
Thank you. Jess, can you take that? And have you got? Thanks.
Commissioner, if it pleases, I appear with Ms Berry for the balance of today's evidence. Before the next witness is called, can I say that I anticipate her evidence will take about an hour or thereabouts. There's another witness scheduled for today after that, Mr Barford. Are you minded to sit late to accommodate his evidence?
How long do you think he'll be?
About half an hour, maybe 45 minutes.
Look, we'll see how we're... does he need to know right now? What's he, online or in person?
He's in person. I haven't had any indication from the Commonwealth about that. I'm just raising it as a courtesy.
Yeah, look, we'll try, I think.
Commissioner, Mr Barford has travelled here. He is present. I don't know if any arrangements have been made to have him stay over, if that was what
I
was
think
being
we'll sit on
contemplated.
there.
It is quite a busy list tomorrow of witnesses.
Yes, it is. That's true. We'll hope for the best.
Commissioner, I call Colleen Taylor.
Now, Ms Taylor, before you sit down, can I ask, would you prefer to take an oath or an affirmation? All right, we'll do that right now.
Your reply is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Copy of the documents for her.
Can you do it?
Now, Ms Taylor's got a folder in front of her. I don't know, is that the documents you're going to refer to, or?
I was going to get her to identify that folder, Commissioner.
I was just going to say there's one sitting here if she needs one, but that's it, is it?
Well, it's the documents that I'll get her to explain what that
Go
is.
right ahead.
Ms Taylor, would you please tell the Commission your full name?
Colleen Mary Taylor.
And you have provided the Commission a statement dated the 8th of December 2022?
Yes,
And you have a folder there in front of you, Ms Taylor?
yes,
Is that a folder of the documents you had regard to when you prepared your
yes.
statement? And which you've referred to in your statement, is that right?
Sorry, what was that?
And the documents which you've referred to in your statement?
That's right, yes, thank you.
Thank you. Ms Taylor, you're presently retired.
That's right,
You were formerly an employee of the Australian Public Service.
yes,
And would this be right? You started your employment in the Australian Public Service on or about the year 1984,
that's right. It was in September 1984.
and you were employed then by what was then known as the Commonwealth Employment Service.
That's right, yes,
And was the nature of your role at that time as a frontline worker assisting customers.
That's right. I was called an employment officer then, so it was counter work.
Okay. And you worked between 1992 and 1998 in the Student Assistance Centre.
That's right, yes, and that was processing claims for student or different types, youth allowance, Aus study, etc. And also I would go out and talk to students at schools, TAFEs, universities about the schemes, promoting it, yeah.
And at that time you were in Launceston, is that
That's right, in Tasmania, yeah.
And is this right? In 1998, the CES and the Student Assistance Centre effectively merged and became Centrelink, is that right?
That's right, we got absorbed into Centrelink when it was created, yeah.
And you then became a Centrelink employee.
That's right, yes, and I was stayed an employee of Centrelink basically from then till I retired, yeah.
You moved to Brisbane in 2001.
That's right.
And then you took up a position in 2010 as a compliance officer
That's right, yes,
in Centrelink.
that's right.
And from 2011, you worked in a range of teams in the role of a compliance officer, is that right?
That's right, yes.
Paragraph 12 of your statement, you describe part of your role as a compliance officer in that context, quality checking of the work done by other officers. You see that?
Yes, that's right, yeah.
And that included their use of debt calculation tools.
That's right, it was, yes.
And is that a reference to tools used by compliance officers to work out whether recipients of Social Security owed a debt to the Commonwealth?
That's right, yes. So it would be calculating their entitlement and then, you know, may or may not result in a debt, yeah.
Okay. And you, paragraph 13, you say that your role also involved providing assistance to other compliance officers on how to examine a record to assess compliance when a discrepancy has been identified.
That's right, yes, because I had a lot of experience across all different benefit types, and so I had that experience I could bring to it.
Right, and by discrepancy, are you effectively identifying circumstances in which there was a discrepancy between the customer's records and the amount that they were being paid?
Yes, it was a discrepancy between often the data we were receiving from outside organisations, or for example from the tax office, but it could also be other agencies, and we would compare that to what's been declared by the customer. But we needed to know whether we could explain the discrepancy because it may not have an effect on a person's entitlement.
And so there's the issue you've identified, I think, Ms. Taylor, in terms of discrepancy, is information from another source, such as the tax office,
Yes.
That might indicate the possibility that the customer has incorrectly declared their income.
Yes, that's right.
And which might then mean that their entitlements have been incorrectly calculated,
That's right, yes.
and therefore the discrepancy would need to be examined to ascertain whether in truth there's been a misdeclaration.
Yes.
And am I right in understanding your evidence that just because there's a discrepancy doesn't mean necessarily that in fact there has been a misdeclaration of income, correct?
Absolutely, yes. There was lots of reasons why you could explain what the discrepancy was, and there was no fault or blame or debt or anything. The person had received their correct entitlement.
For the assistance of the non-compliance officers in the room, which is generally the case here, can you give us an example of a type of type of discrepancy that might readily be explained?
Yes, well, in the case of the information that you get from the Australian Taxation Office, which would be how much income was paid by the employer in that particular financial year, well, for example, the money could all been paid prior to them going on to a Centrelink payment. So, for example, they would provide to us an employment separation certificate and that you had proof then that they'd stopped work with that employer prior to claiming, for example, unemployment benefits or whatever it might be. It also could be at the other end that they actually started the work after they went off Centrelink payments. You also had instances where the type of payment, the discrepancy might be as a result of, for example, a termination leave payment, which we actually code on a different screen. So the data match was comparing the information from the tax office with what was on the Centrelink earnings screen. But things like termination leave pay were on a different screen and wouldn't then come up. So you could look at that and you could explain then why there was a difference. There's also things like people would receive bonuses, commission, a number of different things that would appear on different screens. There might be a compensation payment, which is also on a different screen. Yeah.
Okay.
But so I can understand about the different screens. Are these payments that wouldn't figure in the entitlement calculation? Or what?
It would be included, but it just wouldn't be on the earnings screen, which is what the data match between the tax office, but when we're talking about this particular employment income issue, it's what's on the earnings screen, which is the employment income, and that's what it compares,
Okay,
whereas
and so
other income will be on other screens.
I'm a bit slow about this, but to make sure I understand, you've got an earnings screen. It will show you a figure that might be less than ATO is saying.
That's right.
But the difference is really that on separate screens you have these other amounts.
That's right. Spot on.
Yeah. Okay, thank you.
Thank you. So, at paragraph 18 of your statement, you state that you used to process old-style PAYG payment summary reviews.
Right.
And by that, are you referring to prior to the Robodebt scheme, reviews of customer entitlements by reference to these discrepancies between the ATO PAYG data and what had on its face been declared to Centrelink?
That's right.
Okay. And at paragraph 19, you set out the process, is that right?
That's right, yes.
Okay, and you say that you would first look at the customer record if there was some information that could explain the discrepancy.
Yes.
All right, and can you give a very short, brief example of a situation where an explanation could be seen on the customer record?
Well, as I mentioned before about the employment separation certificate.
And can I just interrupt you there in terms of the employment separation certificate example? Is that a situation where the information from the ATO describes income over a period, say for example a year, whereas the separation certificate indicates that within that year the customer was not working? Is that right?
That could be the case, but also the case could be that the dates on the PAYG payment summary were within that tax year and did identify, and that's why we always said if the dates are less than the full financial year, an obvious thing might be to look at whether that's when they finished work or that's when they started work, that's when they went off Centrelink payments or on to Centrelink payments. So that would be an obvious thing. So the example you gave, yes, but there's also a further example then, yeah.
Okay. Just in paragraph 21 of your statement, you say most of the time debts would be calculated by entering the actual gross wage earned in each employer pay period into the customer's Centrelink fortnightly period.
Yep.
What would be the usual evidence used to ascertain the actual gross wage earned?
Yes, well, after we'd first discount the ones where there was no discrepancy, then we would contact the customer, and if they replied, because often they weren't at that address anymore, so you didn't always get a reply, but if they replied, it was very unusual for them to have a full set of pay slips. So we always then contacted the employer whether the customer had replied or not, except I think I can only think of one case where someone had a complete set of pay slips. So then you'd write to the employer, and you would have to write to all the employers, because it's not just the employer that the tax record has. You'd have to then contact all the employers that the customer had declared, because you need to find out whether, for example, the customer might have declared it under the name of the work site, but the PAYG was under the labour hire firms. So they might have declared earnings for 5 or 6 different work sites, but it all related to this one PAYG from the labour hire firm. So you would have to then try and work out, well, are any of these employers trading names of the business entity with the tax office? So you do that. But anyway, when you found out that they declared other employers, you would then write to them, and you would might have to write 2 or 3 times. You would get the information, and then going back to your question, yes, you would use the information that the employer gave us on their earnings. You would take away any income that related to a different type of coding, so bonuses, compensation, those sort of payments. And then you would use our calculator tools to input the information from the employer weekly, fortnightly, whatever pay slips they were, into the Centrelink fortnight. Yeah.
So you generally use actual evidence of fortnightly income.
Absolutely, yeah.
And you say in paragraph 22 that it would be very rare to use income averaging over the period of PAYG, of the PAYG summary to calculate the debt. You see that?
That's right, yeah.
Now, by averaging, income averaging, are you referring to the practice of taking the PAYG data obtained from the ATO,
That's right, yeah.
which wouldn't be data of income per fortnight?
That's right, it would just be over a period. Most often the information from the tax office just defaulted to the full financial year. But in some instances it would have a start date and a finish date within that tax year. So when you apportioned, you would apportion across that. But you knew that that would be wrong. And so...
If I could interrupt you. Yes. So you say you knew that would be wrong. So when you say averaging, do you mean to be describing a process where an assumption's being made that the recipient is earning the same amount of income in each fortnight?
Every single fortnight, yep, that's right.
That's under
So
consideration.
there's no up and down. It's just straight across the board from the start to the finish date of whatever the dates we've got. And that's why we would always check the customer records if there was anything we could find. There might be a pay slip that had been provided with a year-to-date figure on it, that we could use that. So we try and find out as much information as we can to try and condense that period, so you would only apportion very rarely and try and make it as concise as possible. Okay. And we even use things like, I would get a customer to get a bank statement that would show when it would only be the net pay when it went into their account, and then we had a calculator that would work out what the equivalent gross income was. So we went to all those lengths to try as much as possible to have the exact figures, yeah.
All right, thank you. And you say in paragraph 23 that averaging would also often result in customers losing the benefit of accruing income bank credits during fortnights where they did not work or earn very little. Can you just firstly explain what an income bank credit is?
Right. It had a variety of names. We had a student income bank, there was working credits, work bonus was the other name used for pensions, and it was basically across a number of different payment types where when a person wasn't working or was earning very little, we would put aside these credits that they would build up, and so that when they did earn more than would normally allowed and would normally reduce their payment, they could basically dip into those credits and still get their full payment from Centrelink. So for example, students, they could build up to 10,000 credits, and most students, if they're working, work full-time in the holidays. That's the nature of it. So they would build up 10,000 credits. They could then work full-time in the holidays and still get their full Austudy Youth Allowance student, whatever it might be. And the same thing with pensioners. They would build up these work bonus credits and they would go and work, say, at harvest time or whatever it might be, just for a very, very short period, could still get their full pension because they'd been using up these work credits. So you had that, you could build it up, you could lose it, build it up, lose it, yeah.
If I could interrupt you again.
Yeah.
And by assuming that the recipient is earning their income in the same amount per fortnight over the entire year, does that deny them the ability to get those credits?
Yes, that's right. So, you're using potentially, well, it depends on the amount, but you're potentially saying there's no accrual of credits because, it's the same every single fortnight.
Okay,
And so the debt will be wrong.
all right. You say at paragraph 24 of your statement that you were first told of the changes to compliance practices which were going to become the Robodebt scheme,
That's right.
and then you talk about the rapid response model in paragraph 25. Can you just tell us what the rapid response model was?
Well, basically, what was happening was that the difference, I suppose, is that we no longer write to the employers, and that was the big difference. And so, for example, I'll just refer to my notes here. So the initial, what I would think of as rapid response 1 and rapid response 2. So the initial one is we write to the customer. If they contact, we ask for pay slips. If they don't contact, then we just use the data, but we don't. The big difference was we no longer write to the employers.
Okay, so I'll just summarise. This is what you're describing as rapid response 1.
Yep.
Is this what was in some other context described as the manual intervention?
So yes.
And it was effectively what became Robodebt and had a number of elements of what became the final form of Robodebt as you understood it.
That's right.
That is contact with customers by letter, asserting that there's a discrepancy between what the customer had declared to Centrelink and what the ATO was saying about their income, and then inviting the customer to contact Centrelink. But if they didn't contact Centrelink, Centrelink officers would then have to reassess the customer or the recipient's entitlement by reference to this averaging methodology. Right. Okay. And that was different to what had been done prior to that point.
That's right.
Because prior to that point, there was that process of the officer attempting to contact the customer, and whether or not they were successful in contacting the customer, then there would be contact made with employers.
Yes.
Okay. And then you just talk about issues. Sorry, before I move on, at this time, what role were you performing in relation to what you've described as the rapid response?
Yes. Well, I was quality control, if you like, and what it was, there was a number of us, more experienced people who had a range of experience across all different benefit types. Because the people doing the rapid response were newly recruited and, may not have even had very much experience even in a clerical area before, all their work was checked. So everything that they did, whether it was the coding, the assessment, what they looked at, it came through us, and there was a group of us, and then we would check the work and then either return it with explanations of why it needed to be corrected. Yeah.
Okay. And during this time, did you identify any problems with the system as it was then being operated as what you'd call the rapid response model?
Right. Well, there was a couple of different problems. One of them was looking at where it shouldn't even be counted. So could I give you an example?
Yes.
Yeah. So for example, sickness allowance should never have even been part of this process. The reason being that you can only get sickness allowance if you are employed, you've got a medical certificate that you can't work, and your employer has to provide us with evidence that you have no sick leave. So you're still an employee, but you're on unpaid leave. So the whole point of getting sickness allowance is we already have evidence that you are not on a Centrelink payment and getting paid by your employer at the same time. And so, you know, there were people who, for example, didn't have that knowledge, and one person was talking to a customer who had the debt raised against them because they hadn't made contact. And they was ringing in.
Interrupt you, Ms. Taylor. Is this someone who was on sickness allowance?
That's right, sickness allowance. And that person said they would rather pay the debt back than get in touch with their old employer. And that was where I was involved. I was floor walking, and the person, new recruit, said, "What do I do with this?" And that's what he's saying. And I said, "Well, no, it's sickness allowance, you know." But that person didn't have the knowledge. And I said, "No, that they shouldn't be included. You tell him he needs to ask for a review." And so that's that. But he was being told you have to go and provide evidence to dispute it.
And in circumstances where, by definition, if he had sickness allowance, he couldn't have gotten it unless he'd already provided evidence that demonstrated he was not working at the relevant time. Okay.
And the other area that I returned a lot of work for was the duplication of employers. So could I talk about that?
Yes, please.
So what that was the business entity name with the tax office could be vastly different from what a person is declaring to Centrelink. And for example, you could have, I mentioned before about people who worked at different work sites, but they're actually employed by a labour hire firm. You have people who work at franchisees, so for example, you know, McDonald's, but the actual business entity might be a family trust or what have you. And you've got Coles and Woolworths where, you know, there's so many different trading names. And so someone, for example, would get a letter, and I remember an instance where the data match was for Woolworths. The person had declared as Big W. Now, the person who had processed this through to a debt stage, I guess thought, well, this person could be working at Woolworths and Big W, and hadn't queried it. And I said, no, well, you know, like no matter where you worked, the pay-as-you-go payment summary, the entity name would be Woolworths, for example. And so there were things like that that you had to return work for. There was other instances where someone would declare for a farm or under the farmer's name, and it'd be the family trust for something or other, you know. So there were lots of instances, and even things like the ABN number. When customers try to input online a new employer, you start typing something in, which is the name maybe you know it by. And what happens is it comes up with a list of potential ABN numbers, which of course bear no relationship to the actual entity ABN because you've typed in something different. So you just pick something. The other problem that happened a lot was that people were trying to create a new employer record and they couldn't. So they knew they had to declare their earnings, so they just picked an employer that was already existing on their record that maybe they hadn't worked for years, and then just put it under that because they'd satisfied that, yes, I've declared my earnings, never thinking down the track. And this is why that happened quite a bit, and that's why when we did it the old way...
Can I interrupt you,
yes, sorry.
Ms. Taylor? When the last example you've just given, am I correct in understanding that that was a situation where social security recipients would declare what their earnings were, but wrongly state who their employer was,
That's right.
declaring the name of another employer they'd previously worked for?
That's right.
And how did you ascertain that's what was occurring in those cases?
We would pick that up in the old system because we would write to all those employers, and it was not unusual. You'd write to one employer and they'd say, well, they actually finished work in 2012 or something like that, and here you've got earnings declared for that employer in 2014. And so you know to look at it further. And then because you've written... Just
to interrupt again, Ms. Taylor, and in that situation, would the next step have been to find the new employer and then verify that, in fact, that the amounts that had been declared
belonged to that employer
and were accurate?
That's right. And often that new employer, if you like, was the one that you had the PAYG data match with. So, but it may not be, it may be another one. And so because you're writing to every employer, either from the tax records or from what they've declared, or from talking to the customer, for example, you'll get valuable information that way. And then you have to work out what earnings, which earnings belong with which customer, which employer, sorry.
I'm going to take you to the period of January 2016.
Yes.
Now, did any features of the rapid response at that time, that is January 2016, change to the way it had been in your experience to that point in time?
That's right. Because what happened then is, as I mentioned before, we have the quality controllers, and they have a forum, frequently asked questions, where we discuss, because we need to be consistent and correct with what work we're approving and what we're sending back. And at that stage, we started to get information on not checking the customer record. And so that was the big change. So it changed in that we no longer contacted the employer. Then it changed again to say we no longer looked at the customer record for valuable information that would tell us that there shouldn't be, there's no discrepancy, there's no debt. Yeah.
Can I just ask you to look at a document, and I'll ask it to be called out, as it seemed relevant to what you've just said, Ms Taylor. The exhibit number is 2529. Doc ID is CTH.3001.
Yes.
.0035.
Yes.
.3159_R.
Yes.
You've got a hard copy of that in front of you, don't you, Ms Taylor? Okay. Now, just I'm going to ask you some questions about individual parts of this document, but before I do that, can I just confirm the nature of it? You can see that there are what purport to be a number of emails in the document delineated by some boxes. Do you see that?
Yes, that's right.
And is this an accurate description of this document, that effectively what you have done is collated a series of emails from about this time of January 2016 related to this point that you've just discussed with us about being directed not to, I think the word you used, information not to look at the customer file?
That's right, yes.
Okay. I'm just going to ask you about the first box on the first page.
Yes.
And that would seem to be an email from yourself to the address is bi.qdo.crrt.brisbane. Does that
Yes, that's right.
have some significance? What is BI?
Business integrity. QDI is, QDO is, yes. I'm assuming it's something to do with quality, QDO.
Does it assist?
Yeah, so RRT is Rapid Response Team. Quality Development Officer, I think.
All right. And what was the quality development officer?
Well, I would think that this is people who are looking at the basis for us to make decisions. So it's making sure that we are following policy and that we are consistently providing, if you like, a quality service as far as checking. So it's the quality checking. And you would have to make sure that we're all being consistent, because there might be any number of quality checkers across different work sites. It's just, you just pick in people who've got experience, then because you're doing it, you don't have to be sitting together. And so we had to have a forum where we were discussing these things. So that's where we would have this frequently asked questions forum. Okay. And that would be the audience, and there'd be questions and answers, and we would look at that, yeah.
Okay, so when the words, please escalate this request urgently to Compliance Help Desk, yes. What was the Compliance Help Desk?
Well, that was where we could basically go, it was our go-to place for finding out, well, you know, what are the rules, if you like, that we should be following, you know, and particularly if we were, like, for example, you might return someone's work to them and they would say, well, this is not happening, you know, we've been told this, and so we would then query it and Yeah.
Okay. So the words below that in blue are PAYG FAQ, 27 January 2016. What is the words PAYG FAQ 27 January?
Yes, well, that was the pay-as-you-go team, the data matching team, if you like, frequently asked questions. This was actually a forum. It was like a newsletter almost thing that we could access. And then what we would do is if we had a query, we would type it up and then it could be discussed amongst all the quality controllers or quality checkers.
Okay,
And
if
also
I
then
interrupt.
could be forwarded on to the policy help desk.
Okay, and so does this refer to a question for that forum, which is identified in those words in bold below the words audience-all?
That's right, yeah.
And
So
then
that,
the response from the FAQ people is in the answer section?
that's right, yes. So I'd cut and paste that into the email, yeah.
Yes, and your words underneath the words in red, please raise my concerns about the final sentence highlighted in red. Do you see that?
Yes, that's me.
Okay. And the words highlighted in red were, CEOs do not need to interrogate the customer record to search for payslips or other documents that the customer may have supplied in the past, i.e. prior to the intervention start date.
That's right.
Okay. And was that, to your understanding, a change in the way in which the rapid response, as you've described it, had been administered to that point?
Absolutely.
Okay. And was that of particular significance to you?
Yes, because there was so much valuable information and you knew from the type of payments that there would be something on the customer record. You know, I mentioned before the employment separation certificate, information from sickness allowance customers. You know, there's so much information on the file that can discount that we need to even go ahead with the review. Yeah. Or it might be information that you can use to, as I mentioned before, condense the periods that you're apportioning. Just say, look, there's a payslip there with a year-to-date figure on. We can use that. Yeah.
Okay. And the separation certificate example, in fact, is cited by you just underneath the words, please raise my concerns.
That's right.
And then you develop your concerns at the bottom of the page, and then over the page with a series of bullet points concluding with, as a compliance unit, we should not be the ones stealing from our customers.
That's right.
What were you referring to?
Well, if we know there's no debt, and yet we're sending a debt notice out to someone, isn't that stealing?
Right, and is that what the effect of what was this direction about not looking at the record?
Because if you know from a 30-second look at a customer record that the information that you're getting from the tax office relates to a period, for example, that before they went on to a Centrelink payment, and it's quite obvious, and you can locate it quite readily, and you're saying that if that customer, well, later on we're saying if that customer doesn't contact, you just send out the debt notice. Well, that's,
Yes.
I mean, if there's no debt and you're sending out a debt notice, expecting them to pay that back, how is that not stealing? Is the way I saw it. And particularly as we were a compliance unit, the whole point of our unit was to make sure that people were doing the right thing. And here we were doing the wrong thing.
I see. Now,
And then I think the response is at 3163 that you get, Ms. Taylor. Help desk response.
call out the words help desk response. Is that the response you received?
Yes, that's right, yes.
And the information in blue is the same thing that you had highlighted
That's right,
in
up the
red
top
to
there.
make it
They
clear.
do not need to interrogate the customer record to search for payslips or other documents that the customer may have supplied in the past, that is prior to the intervention start date. So it was saying that the onus is on the customer to provide all this information sometimes again, and they may not have kept a copy of the employment separation certificate because that's actually signed by the employer. They may not have ever even seen it.
Right. And it would be right from the various emails that's extracted in this document that you pursued the issue about not being allowed to check the customer file.
Yep.
And can we take it that the response was consistently along the lines of what we can see in the document or the page with the last 4 digits, 3168?
Oh, yes.
Call those words out.
Yep.
In the case
right.
of the PAYG interventions, the customer has been issued with a letter advising the details of the match data and asked to contact to discuss. This gives the customer the opportunity to tell us about any documents that they may have provided in the past that is relevant to the match data. In cases where the customer chooses not to contact, they are aware that the match data will be applied to their record. There is nothing to stop staff having a look at the record to see if there is any information relevant to the match prior to applying the match data. However, in many cases, the matches are from a couple of years ago. In these cases, there is no expectation that staff need to investigate the record to look for documents that may apply to the match year. Basically, the policy is if the customer does not contact, we apply the match data.
That's right. And you know, if I could comment on that, you're assuming that the customer gets the letter for a start, but the way the letters were worded, there was often no reason for the customer to contact us because it said in the letters, we're checking your employment income. And time again, 8 times in one letter, we're checking employment income, check your employment income. And the information they're given from the tax office is the employer name, the period, we say period of employment, the tax office says payment period, and then the amount. If you look at that, what's there to dispute? Yes, that's right. You're checking my income. Yes, that's what it was on, the tax office. So there's no reason for anyone to actually contact us and say all these wonderful things about having a meaningful discussion and providing information and being aware of this and aware of that. It's just not happening.
Just to summarise your point there, what the customers are not being told in the letters is that if the customer doesn't respond, that the data that's been declared to the ATO will be averaged over each fortnight.
That's right, yeah.
That the
You're not
period
going to understand the complexities of that. And if I could mention the example I said before about someone on sickness allowance, you look at that, it says who your employer is, the period of employment and the amount. Nothing to dispute because you are an employee, you're just on unpaid leave. So there's nothing for you to dispute. You're not going to know that we've said, oh, well, obviously you must agree with our data. We've averaged it out across the whole year and raised the debt for all the period that you're on sickness allowance. And so you don't know anything about this until you get a debt advice. When you get a debt advice, you ring up and you're told you have to go out and get the pay slips. Thanks very much. You know, it just assumes there's this wonderful communication where people are advised everything they need to know, and they talk about if they choose not to contact, and that's why I wanted to labour that point, is it's not a conscious, I choose not to contact, as if, well, I'm obviously pleading guilty. You know, there's no reason for you to contact because the way the letter is worded, do you agree with this? Well, what's to disagree?
So when you say when the customer got a debt advice, are you talking about under the old system?
No, this is rapid response.
Oh, sorry.
Because under the old system, we would have known, well, that sickness allowance, there's no debt. You would look up the record and you would see that there's a letter or a form filled out from the employer to say they don't have any sick leave, we can't pay them.
All right. Now, subsequent to this period, you recall that the scheme changed and became what was known as the online compliance intervention.
Yeah.
And that rolled out in about September of 2016.
That's right. August, September, yeah.
And what role did you occupy in relation to the online?
Well, there was only really one role there, and with this particular, the online compliance, what that meant was that we took away the opportunity to have a discussion with a customer. They're supposed to go online themselves and tap away furiously. What my role was is that there were about 8 of us. We were working in another review team at the time, and because of our experience in doing debt calculation tools, that was multi-cal it was called, we were asked to go down to that team, the online compliance team, and to check that the way the system had calculated the debt was correct by replicating it on this multi-cal manual calculator, and then say, yes, so system has worked out that debt right. And if we said, yes, that's fine, the debt notice would have gone out. Yeah.
Okay. And how long did you stay in that role?
Only a matter of days.
Okay.
You want me to say why?
Why?
Oh, sorry. Well, what happened was the first 3 cases we came up against were duplications of employer. So, for example, you had the customer had declared a deco, the PAYG payment summary was a deco industrial. That was their business entity name. This process, because the customer hadn't contacted, was applying the match data as an undisclosed employer with something so obvious as that, because no human eye had seen it. And so we said, and then the other example was there was an apostrophe missing and a PTY LTD missing from what the customer had declared to what the business entity name was with the tax office. And there was another one, I can't remember. But anyway, so we said, no, the debt's wrong, the calculation's wrong, because you've doubled up. This employer is the same, it's quite clearly the same employer. And so this debt will be wrong. And we were told, no, your job is just to check that with that data in there, the way the system calculated the debt at $2,500 or what have you, that is correct. And because what we would have to do to do it manually under multi-cal, we have to replicate. So I would be putting the employer earnings down, and I put 1 for a deco industrial, and I'd put 1 for a deco, knowing it's the same employer, and et cetera, et cetera. So I know one of the persons there said, no, I can't do this, and left. And then I argued the point, and they said, well, if you don't like it, you can just, go. And so I thought, oh, well, I'll go back upstairs and, to say, you just can't do this to people. And so that was my experience with the online compliance. Yeah.
So this wasn't about September 2016?
September 2016, yes.
And am I right in understanding your evidence that effectively your role was to check that the system was performing in accordance with the design? It wasn't to check whether there were errors because it was ignoring relevant facts on the file?
It was purely to check that the way, with the information that was put in there as a result of this review, the information created a debt, and we were to check that that debt was being calculated correctly. We weren't there to check that the data inputted was correct.
Right. Okay. I'm going to show you a document, Ms. Taylor, another document. This is Exhibit 2530, Doc ID CTH.3001.0035.2921_R. It's Exhibit 2530. And it's an email chain. If we can go to the second last page, bottom of the second last page, which is last 4 digits, 2923.
Yes.
We call out the email at the bottom of the page, which goes over the page.
Yes. Yes.
So this is an email from Mr. Clark, 10th of January 2017.
Yes.
Subject line is an update from the National Manager. And it opens with reference to the Christmas break and to the recent media interest in our increased compliance activities
Yes.
in respect of the online compliance intervention. And you recall there was a degree of media interest around that.
Yes, that's right. Yes, there was, and I think there was also, well, within the department, there was a lot of talk about a whistleblower, and I think there was a lot of, trying to find out who it might be. So people were talking a lot about what was in the media, and we were also getting information from what was called Media Hub, so counteracting what was in the media to reassure us and just say everything's fine. And
Did you, at about this time, were you having discussions with your colleagues in Centrelink about the OCI?
oh yes.
What, in general terms, was the effect of those discussions?
Well, mainly in relation to the small group of us who went downstairs and were doing the checking. That was just about all we could talk about, was just how could you stop it? You can't let those go out, because a customer is not going to know that you've doubled up. It's sort of like, and the attitude was, well, they can always appeal, or they can dispute it, or they can have a discussion, and we've got these specialised staff that can talk them through it. And I thought, it just doesn't happen in reality. So there was a lot of discussion, just how unfair it all was, and sympathy for the information that was out there in the media.
Okay. I think it's the third paragraph in the email. There's the statement, please be assured that the OCI process is calculating debts correctly. Do you see that?
Yes.
And then the words, this process only commences when there is a difference between the data provided from the Australian Tax Office and the income declared by the customer. And then there's words in the last paragraph asking the recipients of this email, which would it be right, this is a general email to...
Yes, it went to all staff, yeah.
All staff.
Yep.
Reminding all staff to be mindful of activities on social media. You see that?
Yep.
And then there's the statement, as always, we are keen to hear from you about any improvements you believe will increase our ability to ensure we are providing the best possible experience for the customer.
Yep.
Do you see that? Now, the next email in the chain, which is on the second page of the bundle,
Yes, I've
call
got
out that start of that email. It's from yourself.
That's right.
The 11th of January to Paul Butler.
Yes, he was my team leader, because he had said if you've got any concerns to put it through, I think he said something about through your local leadership team.
Yeah. And you'll see, or you'll recall that in your email, you firstly addressed the point about the process only commencing when there is a difference between the data provided from the Australian Tax Office. And you say in respect of this, I believe this unfairly implies that there must be something to it, otherwise we wouldn't have a data match, and I wanted to respond in defence of our customers.
That's right.
And I won't ask you to go through the detail of what the defence was, but is this right? It was essentially along the lines that there could be any number of reasons to explain the apparent discrepancy between the ATO data and what had been declared to Centrelink.
That's right. And it was in response not just to what he was saying, but also there was a climate of almost saying to customers, well, you wouldn't have this problem if you declared correctly. And it was in that sort of vein to say that, well, we've got a data match, so, there's something wrong, if you like, when quite clearly there are lots of examples where there's nothing wrong, there's nothing there.
And what were you trying to convey by this email?
It was really about, look at the specifics of this as to why you know, the data match, you can't assume that the data match implies that there's a debt there. And I think if it harks back to, if I may, when we first heard about this program, it was pushed on the basis that there was I don't know whether it was a data match or whatever it was, but they had found that there was something like $450 million worth of recoverable debt was the word they used. So it was implying that, you know, oh my God, people are ripping off the system. And so it's sort of like it's fair game. And so if you then bring that forward to what we found was the data match, where we could find so many instances where, you know, it was way out because of this duplication of employers. But if you carry on that attitude that there's a whole lot of people ripping us all off, and so, you know, when there's a discrepancy, well, there's something in it, and, you know, it then bleeds into how you treat people, yeah. And so that's what I wanted to convey, is there's lots of examples where there's nothing in that, there's no discrepancy. So don't feel as if you have to go at people, yeah.
What did you want to achieve by sending this email?
Oh, gosh, at that stage, I think I just wanted them, well, certainly, to have the big thing was to make sure there was a human eye on them, that particularly the duplication of employers, you had to look at that. So we'd already sort of, I suppose, you know, had the fight with, you know, with the review team about, you know, these are going to go out, you know, even with the duplication of employers. But you would hope that, I don't know, I just wanted to challenge what he was saying, if you like, yeah.
Now, on the first page, the bottom of that page, I won't take you to it, but there's a clarification you provide and a further email to Mr. Butler. And then, but in particular, I want to call out the next email in the middle of the page, this time from Mr. Clark, the author of the original email.
Oh, yep.
Dated the 18th of January.
Yes.
Addressed to yourself.
Yes.
And he thanks you for the time to articulate your thoughts, and says various positive things, and then concludes with, I can't promise you that we will be able to respond with details of direct changes made as a result of your feedback, but I can assure you that it has not fallen on deaf ears and will be used as we continue to refine and improve the implementation of these budget measures. Again, thanks for taking the time to articulate your thoughts. Mm-hmm. You remember receiving this email, Ms. Taylor?
That's right, yes, yes.
How did you feel when you received this email?
Well, I was actually quite impressed, because I thought, oh, great, he's getting all this information, because one of the things was in his original thing, he said, you know, if you've got any suggestions, you know, bring them forward through your leadership team. So that's the other thing I wanted to achieve with my email, was to add in my suggestions. And I thought, oh, and particularly when he said that he was getting it from numerous staff, customers, the minister and external agencies. And I thought, wow, all that noise, surely something will happen, you know.
Could the witness please be shown Exhibit 2531, Doc ID CTH.3000.0024.8495_R?
Yes.
Now, do you see this is an email dated the 25th of January 2017?
Yes.
And it's headed A Message from the Secretary, Catherine Campbell.
Yes.
Remember receiving this email?
That's right. We all got it. It was all staff email. We got regular messages. Yes.
Okay. You'll see that you'll recall that it said refers to a lot of media reports about the compliance processes.
Yes.
There's a thank you to staff about the work done by staff.
Yes.
A statement about the work that we do is to ensure the integrity of the welfare system.
Yes.
And then words about media commentary about the work we do is nothing new. It is important for me to address some recent incorrect reporting with you directly. It says how we match records with the Australian Taxation Office is not a new process. We have been doing it successfully for many years. And then these words, there have also been no changes to how we assess income or calculate and recover debt. I won't read out the full email to you, but how did you feel when you received this email, Ms. Taylor, in the context of the previous.
Well, that's right. It's because you sort of thought, they're obviously hearing all this information because the previous email was like, oh, we're getting all this information, it's really helpful, and, okay, we won't tell you specifically what changes or thing, but things are happening, and there are changes. And then this is sort of like, well, actually, no, things are going very nicely and we haven't changed anything. And when quite clearly, and particularly how we calculate, to say that, we absolutely have changed how we calculate the debt. And even recover debt. I used to work in debt recovery, and an absolute last resort was to contact collection agencies when we just, all avenues of trying to locate the customer, we just couldn't. But now it was like, well, I don't know whether they had a contract or what, but everything was hived off to Dun & Bradstreet. Well, that's a big change in debt recovery, because there's certainly that, there's more fear to the customers, with something like that, even though they would say it doesn't affect your credit rating, your credit score, or whatever it is. Just the thought it's a collection agency in everyone's mind, it's wow,
Okay. I'm going to show you another document, Ms Taylor. It's Exhibit 2532, Doc ID CTH.2009.0007.5968_R.
Yes.
This is an email from yourself to Catherine Campbell.
Yes, that was my covering sheet, yep.
Yep. The then secretary.
Yes.
Copied to Hank Yongan.
Yes.
Who is Hank Yongan to your knowledge?
Yes, he was our media spokesperson, and he used to bring out a thing called Media Hub, which responded to information that was in the media. So that was for staff to, well, presumably to get a balanced view of things and to disseminate information.
Okay.
So he was always the person that would appear on our behalf on television or radio or newspaper.
Okay, and it refers to 3 attachments.
Yep.
Just ask you to confirm the third attachment that's listed there, the in confidence emails from January 2016. That's that first
That we've just talked
document
about.
that had the boxes in it with the
That's right,
emails,
yes,
talking about directions in 2016 about looking at the customer file.
Right, yep.
Okay.
That was to show that I'd raised these a year previously. Yep.
Yes. Next document I want to show you is what was the first attachment. That is the response to the secretary document.
Yes.
And that is Exhibit 2533, CTH.2009.0007.5969_R.
Yep. Yep.
Now, I'm just going to call out the words at the top of the page, starting with response to the secretary and ending with the section, the sentence just after the words in red.
Yep.
All right. Now, you'll see, first of all, this is the first attachment to that email that we just looked at.
That's right.
Okay. And you'll see there is the reference to that general email from the secretary we looked at just before,
Yes.
and the quote from the secretary's message, and in particular the words I specifically identified with you before. There have also been no changes to how we assess income or calculate and recover debt.
That's right.
And then these are your words. Please allow me, as a loyal employee of many years standing who has only ever raised concerns in-house, to respond to you directly, as your statement tells me that you are being misled, and I want to ensure my words reach you. We cannot find a solution if the problem is not correctly identified. It is possible we are not even looking in the right direction for a solution. And then the words in bold, there has been a very dramatic change within the last 18 months to the way in which compliance assesses income and calculates and recovers debt. See that?
Yes.
And was that your belief, that there had in fact been a dramatic change?
Oh, absolutely. Yeah.
And in summary, was the change, firstly, the shift from reviews, having compliance officers looking at the file for explanations as to the discrepancy between the ATO data and what had been declared. And then the shift from using averaging very rarely to it effectively becoming a default mechanism if the customer did not respond to the letter, in circumstances where, on your assessment, there would be it's not obvious from it was not obvious from the letter that the customer would have any reason to respond to the letter.
And also to the other big changes that we no longer wrote to the employers to get the information.
Yes. And that was, in your assessment, a dramatic change.
Oh, yes.
And for the balance of this letter, were you seeking to explain to the secretary why that was a dramatic change?
That's right, yes.
And
Oh,
I won't take you through it in detail, but you did that with reference to, first of all, the old-style PAYG payment summary reviews,
yep,
the early phase of the rapid response that we discussed,
yep,
and the phase from January 2016 where you were being directed not to look at the file,
yep,
and then onto the online compliance intervention
yep,
where it was being done effectively by a computer without reference to the customer.
that's right.
Okay. Now, that can be taken down. You recall being contacted by Karen Harfield and Adrian Hudson in relation to your correspondence to
Yes, yes.
Okay.
Very quickly, yeah.
How quickly?
It was the same day, I couldn't believe it. And, well, none of us could. We just thought, oh, wow, you know, and so it was saying, yes, we've received this, and those two people would then have a phone hookup with me, and that was arranged, I believe, for the next day. And we thought, oh, and so then I was, you know, my team leader and manager were helping to prepare me, and they said, do you want us to sit with you? And I said, no, I should be okay. You know, it was just sort of that thing of, oh, wow, you know.
Okay. And did you discuss with these persons what you'd conveyed to the secretary in your correspondence?
Which persons do you mean?
I'm sorry, Karen Harfield and Adrian Hudson.
Yes. So what I did in preparation for the phone hookup, I did some notes myself, which was basically this all over again, but I'd added some of my own suggestions, what could be done at the end, and I basically used that as my prompt sheet, and then I think it was quite a considerable amount of time. I can't tell you exactly how much, but I went through it all and explained it all, and yeah.
Okay, when you say explained it all?
Yes, it just went through basically why I felt that, you know, that it was wrong. Yeah. That there were aspects of it where there was an assumption made that was incorrect. So there was an assumption made that, you know, customers would contact and have a meaningful discussion about it. There was an assumption that if they didn't, then obviously they're, well, in effect, pleading guilty.
What about problems with averaging?
Yes, oh, absolutely, yes. I went through all of that because, you know, it was just, you know, apart from denying people the access to income bank credits and things like that, it just, well, I don't know, it's just wrong. I'm sorry.
Problems in terms of the system not checking, a human being not checking what was on the customer's file to ensure that there were no inaccurate assumptions underpinning a calculation.
That's right, yes.
You raised that?
Yes, oh yes. Mm.
Okay.
So I raised everything that was outlined in the letter, yeah.
Okay. And
In the
then
email.
at the end of the conversation between these persons, or with these persons, Ms. Harfield and Mr. Hudson, what happened?
Well, after me going on and on and on, at the end, she said, well, that's good. So what you're saying is the old system used to be very time-consuming and lengthy, and this is going to be much quicker. And my jaw just dropped, and I thought, what? And I said, no. Anyway, and then I went out to see my team leader, and I said, I don't think she listened to a thing I said. I was really down about it, yeah.
Okay. Do you recall, subsequent to that telephone hookup, Miss Harfield coming and seeing you at the Brisbane office?
I'm sure she probably did, but I just can't remember. It probably was, maybe it was a meet and greet with the managers and me. I honestly can't recall it, but I'm not saying it didn't happen, but yeah.
I'm going to show you one last document, Ms Taylor. The document is Exhibit 1261. ID is CTH.0033.001.0489_R. It's a letter dated the 17th of February 2017, addressed to yourself, reportedly from Melissa Golightly.
Yes, yes.
Okay. Do you remember receiving
I
this
did get
letter?
that, yes.
Okay. And if we call out the second paragraph,
Mhm.
it refers to a recent meeting with Ms Harfield and Mr Hudson,
Mhm.
and you having a further opportunity to expand on the points you made.
Mhm.
And the words, "I can assure you that your suggestions are being considered and will be taken into account in our continuous improvement processes." See that?
Yes.
How did you feel when you received this letter?
Well, I just felt it was sort of a standard reply. At that stage, I wasn't overly confident that things would change, and it was, it was sort of like a continuous improvement process. So it's sort of like, well, wouldn't it be better just to stop and take stock of what's happening and fix it, rather than, well, doing a little bit of improvements here, a little bit of improvements there, and so I wasn't overly, optimistic, I think the word I would use.
That can be taken down. At this time, that is February 2017, what role were you occupying in Centrelink?
I was in the unearned income review team, which was looking at data matches of investment income. So, it might be bank interest or it might be family trusts and things like that. So, and we were doing that the old way, if you like. Yeah, lots of investment and what have you. And then I was also on the phones. So I would sometimes be taking calls from people who had been affected by this. It might have had a debt or something like that, or I might have just taken a call where I had one call where someone rang to make sure that we'd received the information they'd sent in to ask for the debt to be reviewed. Yeah. So I did have some interaction because I was on the taking calls, which could be for any sort of thing, not related to the role that I was doing as a review officer. Yeah.
Okay. When did you finish your employment in Centrelink?
I retired in July 2017. Yeah.
Can you tell us what the reason was for retiring?
I just was spent. I think it was just callous indifference that you just thought, is this what people do to each other? And it was just so sad. And you just thought nothing's going to change. And it seemed that it was ramping up. And I felt sorry for even the people who were being employed in the online compliance team, because they were being employed because, people are ripping us off left, right and centre, and you're the saviours, you're going to be providing this wonderful public service. And they were just bewildered with all this storm that was brewing.
Sorry to interrupt you, Ms Taylor. You're saying that people were being bewildered. Who are you referring to?
Oh, sorry, the new recruits in the online compliance team. Yeah.
How were they being bewildered?
Well, because we were saying this is wrong, and they're being recruited on the basis of, this is right, you're really doing a wonderful job. And
So in terms of you're referring to the messages they were receiving?
yes, that's right, yes.
From whom?
Well, I'm assuming from the people who are recruiting them. Yeah.
Right.
Mm. And
There were quite a few people brought in to assist with the program when it, during 2017.
yes, that's right. Yes, yeah. And I think too, it was just, you were just so sorry for what was being done to our customers, and it was, it was just starting to come out in the media, all the dreadful consequences. Mm.
Commissioner, that's the evidence of the witness.
Right. Ms Hogan-Doran?
Commissioner, there's no questions arising. Thank you.
Okay. Look, thank you very much, Ms Taylor.
Thank you, Commissioner.
For coming along and telling us all that.
Thank you, Mr. Scott.
And you're excused, as we say.
Thank you. Oh, I'm wired up.
Commissioner, the next witness is Mr Barford, but I understand that Commonwealth representatives might have something to raise.
Commissioner, we've just had some discussions if it was convenient. Either way, Mr Barford is available to stay overnight and to return tomorrow afternoon after Mr Morrison's evidence is completed, if that was convenient. I note that Mr Barford has retired from the public service and it may not be ideal that he gives his evidence in two parts.
Yes, okay. And you have found somewhere for him to sleep?
We have, yes.
Good. Who else is tomorrow?
It's Miss Dalton, but I understand that there might be some instructions being sought about.
There are some instructions. So in addition, Ms Dalton was going to be giving her evidence by video link. We're just making some inquiries to see that could be done at a convenient time on Friday. And I anticipate I'll have those instructions confirmed soon.
Is there any chance we could keep it provisionally tomorrow in case things go faster than expected? But
That may be so. I'll make some inquiries. I think what's proposed, so that there's no difficulty in completing Mr Morrison's evidence, he'll go first, and then the other two witnesses will come in behind him.
All right, thank you. All right, so we'll adjourn, will we?
Thank you.
Okay, thank you.
All rise. The Commission stands adjourned until 10 a.m. tomorrow morning.